Please, Lordship. Lordship, I beg to mention hearing item 21.
21. Yes.
So,
What about it?
if this matter will be listed after a week,
After a week?
Lordship.
Okay, you have taken consent from the other side?
Oh, yeah,
Have you taken consent from the other side?
he's not here,
Oh,
Lordship.
he's not here. Okay. Your name?
Laknepong, Lordship.
Learned Counsel Mr. So-and-so has prayed for adjournment. List matter after 1 week.
Lordship.
Okay.
Lordship, I also beg to mention item 6.
Yes, yes.
Here, Lordship, I'm for the respondent number 5.
Mm.
Here, the petitioner and the respondent number 5, they are negotiating the matter.
Okay.
So if this matter may be listed after 3 weeks, Lordship.
Learned Counsel Mr. So-and-so. Yes, yes.
Ma'am,
yes,
so-
yes.
Finally, by order dated 14 July 2025 of the Deputy Commission Dimapur, the matter has been settled.
Matter has been settled.
Matter has been settled.
Okay. let us
Prior
see.
period.
We'll close the matter there.
That's not right, Lordship. 3 weeks may be given.
I've not been instructed by my client,
Okay.
in respect of the petitioner, regarding any
We
negotiation.
have not instructed. So we'll we give, shall we give him 3 weeks?
Last week will be too long, Lordship,
A little longer?
because this is 14 July.
Uh,
Now it's 37. At least more than a month, they have been seeking time.
Mm.
That at least 1 week at the most.
1 week time, okay. All right, 1 week's time.
Worship.
And on the next day, the. and
We'll
then
close it.
to close
Yes,
the
we'll
matter.
close
That's-
it.
That's what it's ordered.
What's the point of keeping it pending, isn't it? Okay, Learned Counsel, Mr. So and so. You are for Learned Counsel, Mr. P. Forte has submitted that he has received instructions and he has submitted the government notification number VLS -4 stroke 2007.
No, this is not order.
Huh? Oh, there's an order. Okay.
The order, I just submitted, not the one I just submitted.
Okay, order,
The
not
order
notification.
dated
Order number.
14th July of the deputy. commissioner.
It's an order, not notification. Okay, order number. VLS -4 stroke 2007 -D stroke PT stroke 2125 -30 Dimapur, dated Dimapur 14 July 2025. And has submitted that the matter has been settled. Learned Counsel, Mr. So and so, for the respondent number
5, Worship.
5 has prayed for time, prayed for adjournment, list the matter after 1 week.
Worship. God bless you.
Or return the, you can take it back. The copy of the order is returned to the Learned, to, you are for government, no?
I'm for the petitioner.
Petitioner is returned back to the Learned Counsel for a petitioner. We'll return it back to you.
No problem.
You can submit it
fact,
on the next date.
In fact, my lady, on the last petition, we have submitted this order.
Okay,
Must be in the report also.
okay, okay. Nalage last line to cut it.
What's made?
Maybe the Lordship,
Mm.
maybe please to mention item number 5.
Mm.
Your Lordship, on the last occasion, on
Mm.
the last order, Your Lordship, I sought for 2 weeks time to seek a clarification on the instruction that I received. However, Your Lordship, the person with whom I should seek clarification with out of station. Your Lordship, this matter relates to wrong fixation.
Mm.
Your Lordship, so it's a technical matter and I need to seek a clarification from a technical person only, senior accounts officer. But since he was out of station, I could not obtain the concrete instruction, Your Lordship. So another 2 weeks may be granted so that like within that time I can see the proper instruction, Your Lordship.
My lord, for the last, with all due respect to my learned friend,
Mm.
for the last congregations, they have been making similar submissions before this honorable board, and this honorable board has granted them enough time.
No, Your Lordship, my learned friend is misleading, Your Lordship. On the last occasion, I have brought that it was under consideration. Your Lordship, I received an instruction stating that it was under consideration. It was fixation has been done. However, the instruction that I received, Your Lordship, I felt that there need to be some clarification on that since it's a technical matter. And I need to make myself understand fully so that I can apprise this honorable court.
Yeah.
Therefore, Your Lordship, on this ground only, Your Lordship, I sought for 2 weeks. However, on account of the senior accounts officer on leave, Your Lordship, I could not able to contact him, Your Lordship. So another 2 weeks, Your Lordship. Otherwise, we were not
My lord,
speaking time on the
that
same
case-
ground, Your Lordship.
in that case, a direction may be issued that on the next day, if it is 2 weeks, then they have placed before this honorable board the status report of that. Clarification.
We will do that, Your Lordship, but the petitioner must also appreciate the efforts we are making, Your
This
Lordship.
is relating to
Wrong fixation.
Wrong fixation of the petitioner's salary.
salary, okay.
Yes.
Learned Counsel, Government Advocate,
Yes, Your Lordship.
Miss
Livika, Your Lordship.
Livika has submitted for time to place a technical clarification relating to fixation of salary of the petitioner. As there are certain
Clarification. There's certain clarification I need to make on
as
the
certain
instruction. I received.
clarifications are required to be obtained. Full stop. Learned Counsel, Mr.
Sure.
Toshio O. Longkumar has raised objection. Full stop. However, adjournment is granted, 2 weeks adjournment is granted to produce the clarification relating to fixation of salary.
Yes,
List accordingly.
A fixed date, maybe, 21st.
21st. 21st will be fine. 21st August. List according to fix list the matter on 21st August.
much obliged.
First.
Maybe it's my reading.
Mm,
Now, leader, mention item 7.
mm,
I'm fully respondent number
mm,
3.
mm.
I responded. I'm yet to find my affidavit. Can you grant me 3 weeks time? That's it.
Learned Counsel Mr. P. Forte, with the consent of the other side, consent
Yes.
has prayed adjournment to file affidavit
Yes.
on behalf of respondent number 7
Number
to
3.
submit affidavit on behalf of respondent number 3, counter affidavit.
Counter affidavit.
Counter affidavit on behalf
Affidavit in
of,
opposition. Right.
okay,
Affidavit in opposition.
affidavit in opposition on behalf of respondent number 3. List accordingly. Time to dila niki?
After 3 weeks.
Lihila, 3 weeks time. List the matter after 3 weeks.
Please, Your Lordship, I'd like to mention item number 22. Lordship, that this matter be listed on 14th next week.
Okay. Learned Counsel Miss
Intila.
Imtila.
Intila.
Imtila, with the consent of the other side, has prayed for adjournment. List the matter on 14 August.
14.
14 August.
Lordship, there's an interim. There's-
Interim order shall remain in force till then.
Much obliged.
Mm.
So, Lordship, I'd like to mention item number 4.
Mm.
If I may be granted another 3 weeks time to file my reply to the affidavit filed by the state.
You have taken the consent?
Yes,
Learned Counsel Miss
Ms. Lucino for the petition.
Lucino, for the petitioner has submitted for how many weeks time?
3 weeks time.
3 weeks time to
File reply to
with the consent of the
affidavit.
other side likiba, huh? With the consent of this other side has submitted submitted for 3 weeks time to file affidavit in
To
reply.
file reply to the state.
Affidavit in reply.
Yes.
List accordingly.
There's an interim.
Interim order shall remain in force till the next date of listing.
Pledge.
Mm. Mm.
Lordship, I mention item number 23 and 24. What are those matters?
Mm.
For the petition in this case,
Mm.
if this matter may be listed after 3 weeks
Okay.
after getting consent from the owner's part.
Learned Counsel Mr. Muazamid,
Yes.
with the consent of the other side,
Yes.
has prayed for adjournment. List the matter after 3 weeks.
Yes.
Mm.
Yeah, please,
Mm.
mention item number 25. Lordship, let the matter come after 4 weeks.
Learned Counsel Mr.
No, sorry.
On behalf of Learned Counsel Mr. Senior Advocate,
Yes,
City Jamil,
yes, Lordship.
has prayed with the consent of the other side, has prayed for adjournment. List the matter after 3 weeks.
4 weeks.
After 4 weeks.
Lordship.
It looks like. Now, I beg to mention item 9. I prayed for 3 weeks to file affidavit.
Learned Counsel Mr.
M. Longkumar.
M. Longkumar, Government Advocate.
Yes.
Learned Government Advocate Mr. M. Longkumar, with the consent of the other side, has prayed for adjournment. List the matter after 3 weeks.
Yes. Other similar prayer for item 13.
Mm. Same order.
Your Honor, also I have a similar prayer for item 14 and 17.
Any objection?
No.
Same order. Mm.
If in item number 14, if my presence can be reflected.
Item number 14 not likhil also. Bakibu same. Item number 14 not. What is your name?
I'm appearing on behalf of Mr. A. Jimomi, the Standing Counsel of Gauhati High Court, Madam. Ms. Lucino, appearing on behalf of Mr. A. Jimomi, the Standing Counsel of Gauhati High Court.
It all 14 day.
Respond number 5 and 6.
Respond number 5 and 6.
Pledge.
Lordship, in item number 8 for admission, if I may be allowed 3 weeks time to file a reply.
Item number?
8. Item number 8. The state as well as the private respondents, they have filed their affidavit in opposition. If I may be allowed 3 weeks time to file a reply.
Okay. Learned Counsel Mr. Muaz Amir, with the consent of the other side, has submitted for 3 weeks time to file affidavit
In reply.
in reply. List accordingly.
Lordship, I beg to mention item number 12. On
12.
behalf of additional GED,
Kindly grant 3 weeks time to file the affidavit.
Learned government advocate,
Pichano.
uh,
Additional AG in team, so.
Pichano on behalf of Double AG.
Lordship,
What is her name?
in team, so.
MTM.
In team, so.
MTM, so with the consent of the other side, you have the consent.
Yeah.
Has prayed for 3 weeks time
Lordship.
to file affidavit
Lordship.
in opposition, counter affidavit.
Madam,
Learned
the
counsel,
state
Mr.
has been listed for several times,
Okay,
and this is the 5th time.
with the consent to
And-
Katidia.
What the central government and state government has not filed their affidavit of reply. So, my humble prayer to the court is that this should be the last chance for both the
Okay.
central government and state.
All right, okay, all right.
Lordship.
Your name?
4 weeks.
Okay, 4 weeks likhi diba, हाँ.
But this should be the last time.
Your name?
NK Asumi, my lord.
Learned counsel, Mr. NKR.
NK Asumi.
NK Asumi, learned counsel, Mr. NK Asumi is present for the petitioner and has raised serious objections stating that several adjournments have been procured by the respondent side. Full stop. Considering the submission, a last adjournment is granted for filing affidavit in reply in opposition. For filing affidavit in opposition. List the matter after 4 weeks.
But
Positively.
this should be the last chance.
List the matter after 4 weeks positively for affidavit in opposition.
Much obliged.
Lordship, I also like to beg to mention item number 15
Okay.
on behalf of additional AG in team, so. Lordship, kindly grant 3 weeks time to file affidavit.
Okay. Yes.
No objection.
Learned counsel Ms. Pichano,
Lordship.
learned government advocate Ms. Pichano on behalf of Double AG. Same,
Lordship,
Ms. Imtian,
in team, so.
Imti Imsong, comma, with the consent of the other side has submitted for
3 weeks time.
3 weeks time to file counter affidavit.
Lordship,
List accordingly. 3 weeks time likhila no? List accordingly.
Much.
Lordship, item number 16 also.
Mm.
He has sought for further instruction. So kindly grant 3 weeks time to file affidavit, Lordship.
Same order. You have objection?
Notice on the respondent is still evident. Notice on the respondent is still evident.
Awaited. Notice, service report, service of notice on respondent number 6. 3 is awaited. 3 weeks लिखी रखी.
Lordship, I also like to beg to mention item number 10. Lordship, I have received affidavit in reply by the petitioner only this morning. So if I will be granted another one time to go through the same, Lordship. Item number 10.
Learned government advocate Ms. Pichano has submitted for time to go through the affidavit.
Lordship, filed by the petitioner.
For affidavit filed by the petitioner as she has received today, as she has received the affidavit today. List the matter after 1 week.
I bless Lordship.
For motion. Item number 1.
In this matter, there are 2 proceedings pending against petitioner.
Mm.
The petitioner is a police personnel. One is the criminal proceeding, which is pending against him, and the other is a disciplinary proceeding. Now, by this petition, I am seeking a stay on the disciplinary proceeding during the pendency of the criminal proceeding on the ground that both the criminal as well as the disciplinary proceeding, they proceed on the identical set of facts and evidence. Basically, that's the issue. Now, basically, that's the.
What is the issue?
I'm seeking a stay of the disciplinary proceeding while the criminal proceeding is pending. Now, if you also may have page 16 of my petition. Page 16 of my petition.
Yes.
This is the application forwarded by the investigation officer to the alert magistrate seeking the arrest of the petitioner. Now, the allegation is that, may I read the content? In inviting to the subject cited above, I have the honor to state that on 3 July 2025 at about 9:30 hours, 2 persons, namely Mrs. Maripol so and so, and Mrs. Mai. Now, these are the two accused, were arrested for possession of illicit drugs, suspected brown sugar weighing 93.7 grams and 4.09 grams, and were forwarded to judicial custody. Now, in this connection, and as per the statement of the accused, Mrs. Mary and Mr. Daniel, that they bought the illegal drugs from Mr. Achingpong. This is the petitioner, Mr. Achingpong, for a sum of rupees 5,200 only. Accordingly, the suspected accused, Mr. Achingpong, so and so, was summoned at WMPS Long Lang on 10 July 2025 and interrogated where he was found to be involved in the incident case and was arrested under the memo. Now, based on this, the accused person was arrested, and if your lordship may have page 21. This is the arrest memo.
This is forwarding, I think.
Yes, it was.
This is not an FIR, isn't it?
No,
An
no.
FIR. Forwarding by the IO.
The accused was arrested based on the statements of the two main accused. Now, at page 21, this is the arrest memo. And the grounds of arrest state that the accused has been arrested for possession in handwritten, for possession / supplying of illicit drugs to Mrs. Mary and Mr. Daniel. Now, these are the two main accused persons. Based on the statements of these two persons, the accused has been falsely implicated in this criminal case. Accordingly, on the next date, at page 22, the respondent, the sole respondent, suspended the petitioner.
Yeah, definitely.
Yes, on 11 July.
Mm.
Hastily, on the same day, the disciplinary proceeding was initiated against petitioner. Memo has been issued at page 23. And the charge against the petitioner in the disciplinary proceeding is also at page 24 on the same ground. Page 24, article 1. That the said so and so with the petitioner was charged for possessing / supplying of illicit drugs to Mrs. Mary and Mr. Daniel.
He's a police personnel.
Yes, he's a police person.
In what capacity?
In,
SI?
no, he's a armed branch constable.
Okay, I'm
Armed
branch
branch.
constable. Okay.
Now, currently, he's under judicial custody.
Mm.
Now, against this memorandum, I've also submitted my written reply as provided under the Nagaland Discipline and Appeal Rules. Now, in my reply, I've stated that since both the criminal proceeding as well as the discipline proceeding, they proceed on the same identical facts and evidence based on the law laid down by the Supreme Court.
Disciplinary proceeding will proceed.
Yes, no doubt. The law settled is that both can proceed simultaneously. But there's a little exception as has been laid out by the Supreme Court. That exception is that if both the proceedings are based on identical set of facts and evidence, it is desirable that the court stays the disciplinary proceeding so that no prejudice be caused to the petitioner or the accused person in the criminal proceeding. Now, in that regard, may I be allowed to rely on one authority? Just relying on one.
No, not today. No, stay today. Let me hear the other side.
It's too early, my lord.
Yes.
Too early.
Yes, that too. It's not a marpit in the office. It's not threatening in the office. It's
Yes, ma'am.
drugs relating to
Yes.
drugs. Not today.
No, but again, your lordship will see. If your lordship may kindly indulge.
Not even corruption. Also direct drugs.
No. But
No,
your
no.
lordship may-
Cannot stay today.
Your lordship may have a moment.
Moment.
Have a
No,
look
this
at
may be-
page 25.
Huh?
Notice may be issued.
Notice.
No doubt, but if your lordship may kindly permit me and have a look at page 25. The
We will
articles,
stay. We will stay after hearing. Let notice go.
there's no seizure memo. Your lordship may appreciate that. There's no seizure memo.
No. I'll not go
The
into those
evidence,
details.
the evidence, the-
Caesar memo and all. I will not go
Ah,
into
yes.
these details.
then may I be allowed to just rely on one authority of the Supreme Court where it says that the little exception. I'm only banking on that little exception. If it pleases your lordship, then your lordship may have a perusal of this authority.
Why do you want a order of?
No, because in the event that
You see, if you give me all those, then I will pass a reasoned order. Do you want a reasoned order now, or later after
I
hearing?
am only seeking your lordship's indulgence to at least for the moment during the pendency of the petition, in all fairness, if the dispute proceeding may be suspended during the pendency, and ultimately.
If you insist, I will hear, and then I will
At
then
least, in all fairness, if.
after all this, then I will pass an order and I'll issue notice. Do you want such an order now? If you insist, I will take it up. Then
No,
I will pass a reasoned order,
I'm just submitting that I have an interim prayer to suspend the discipline.
but I will issue notice.
Yes, ma'am.
Then regarding the interim,
Then he will place his submission. I will hear you out throughout. Then I'll pass the order. He will place his submission. Definitely, he will also give authorities. Then I'll hear you out both throughout.
Very good.
Then I'll pass the reasoned order. You want it now? Or I'll issue notice.
If your lordship pleases, then I can make my submissions now also.
Okay, then we'll proceed with his submissions. Then you'll also place your submission. Okay.
Should I continue?
Yeah. Yes, you give me the authority.
Now, as I was submitting, if your lordship may have page 25 for the petition. Page 25. Now, these are the documents based on which the discipline proceeding is proposed to be held. The first is the list of documents, specifies the arrest report, which I've just read out, and the second is a suspension order. There's no seizure report. And the witnesses, the list of witnesses.
We'll not go into all those.
No. Simply for a prima facie satisfaction as to whether, based on the identical set of facts, now I was arrested in a criminal case for alleged possession.
You cannot go into the criminal case. Now you are against the disciplinary proceeding only.
Yes. Now again, the witnesses which they propose to examine, this is the IO and the two arrest witnesses. Now I have a Supreme Court case which clearly I submit that there's a Supreme Court case, but based on the same set of identical facts. And
I will note it down. No seizure, no possession, no seizure made, and there was nothing, no possession.
The IO and the two arrest witnesses. And those indisputably, they will be examined in the criminal trial as well. Now, charge sheet is yet to be filed.
No seizure memo and
Yes, no seizure memo.
anything else?
And
Nothing recovered from his possession.
Yes. Now, I'm not dwelling on the merits of the criminal trial. No, the criminal proceedings. I'm simply submitting before this court that at least in the interest of fair trial.
Okay. Why trial then? If you're not dwelling on the criminal case, then why you are insisting on fair trial?
Proceedings are on the same set of facts. If you lordship may.
Yes.
If you lordship may see.
Yes.
May I be permitted to rely on one authority?
Yes, of course. I'm hearing you out. Which paragraph?
I'm relying on paragraphs 13, 17, and 34.
Yes, please read.
I'll just read down those short paragraphs. Now, of course, your lordship knows the settled position is that both disciplinary proceeding as well as the criminal proceedings can proceed simultaneously. Now, the Supreme Court at paragraph 13 says.
Because as a district judge, I was proceeding with the departmental proceedings. There were no stays or nothing was such.
But I'm writing on the criminal exception.
We had so many incidents in the district. So I use so many incidents in so many districts. And I was always proceeding in the departmental proceedings. There was no stay.
Yes.
All right, 13, 17 and?
Yes, 13, 17 and 34. May I be allowed to read those? 13 says, as we shall presently see, there is a consensus of judicial opinion amongst the high courts whose decisions we do not intend to refer to in this case, and the various pronouncements of this court, which shall be copiously referred to on the basic principle that proceedings in a criminal case and the departmental proceedings can proceed simultaneously with a little exception. That exception I'm banking on this petition.
Okay.
As we understand, the basis for this proposition is that proceedings in a criminal case and the departmental proceedings operate in distinct and different jurisdictional areas. Whereas in the departmental proceedings, where a charge relating to misconduct is investigated, the factors operating in the mind of the disciplinary authority may be many, such as enforcement of discipline or to investigate the level of integrity of the delinquent or the other staff. The standard of proof required in those proceedings is also different than that required in the criminal case. While in the departmental proceedings, the standard of proof is one of preponderance of probabilities. In a criminal case, the charge has to be proved by the prosecution beyond reasonable doubt. The little exception may be where the departmental proceedings and the criminal case are based on the same set of facts and the evidence in both the proceedings is common without there being a variance. Now it's 17. After that, the Honorable Supreme Court discusses on the principles of law and then comes at 17. After discussing, the Supreme Court says, These decisions indicate that though it would not be wrong conducting two parallel proceedings, one by way of disciplinary action and the other in the criminal court, still, it would be desirable to stay the domestic inquiry if the incident giving rise to a charge framed against the employee in a domestic inquiry is being tried in criminal court. The case law was reviewed by this court in so and so, and it was laid down as ample. The view expressed in the three cases of this court seemed to support the position that while there could be no legal bar for simultaneous proceedings being taken, yet there may be cases where it would be appropriate to defer disciplinary proceedings awaiting disposal of the criminal case. In the latter class of cases, it would be open to the delinquent employee to seek an order of stay or injunction from the court. Whether in the facts and circumstances of a particular case, there should or should not be simultaneity of the proceedings would then receive judicial consideration, and the court will decide in the given circumstances of a particular case as to whether the disciplinary proceedings should be interdicted pending criminal trial. As we have already stated that it is neither possible nor advisable to evolve a hard and fast straitjacket formula valid for all cases and of general application without regard to the particularities of the individual situation. For the disposal of the present case, we do not think it necessary to say anything more, particularly when we do not intend to lay down any general guideline. The court further observed as under. In the instant case, the criminal action and the disciplinary proceedings are grounded upon the same set of facts. We are of the view that the disciplinary proceedings should have been stayed and the High Court was not right in interfering with the trial court's order of injunction, which had been affirmed in the plea. Paragraph 34. This pertains to the facts in this case. Paragraph 34.
Yes.
There is yet another reason for discarding the whole of the case of the respondents. These are the employers. The respondent is the employer in this case. As pointed out earlier, the criminal case as also the departmental proceedings were based on identical set of facts, namely the raid conducted at the appellant's residence and recovery of incriminating materials therefrom. The findings recorded by the inquiry officer, a copy of which has been placed before us, indicate that the charges framed against the appellant were sought to be proved by police officers and punch witness, who had raided the house of the appellant and had effected recovery. They were the only witnesses examined by the inquiry officer, and the inquiry officer, relying upon their statements, came to the conclusion that the charges were established against the appellant. The same witnesses were examined in the criminal case, but the court, on a consideration of the entire evidence, came to the conclusion that no search was conducted, nor was any recovery made from the residence of the appellant. The whole case of the prosecution was thrown out, and the appellant was acquitted. In this situation, therefore, where the appellant is acquitted by a judicial pronouncement with finding that the raid and recovery at the residence of the appellant were not proved, it would be unjust, unfair, and rather oppressive to allow the findings recorded at the ex parte departmental proceedings to stand.
Okay.
I'm submitting that both the criminal proceeding and the disciplinary proceeding they proceed on the same identical facts. That is, alleged possession or supplying of illicit drugs. The witnesses in the disciplinary proceedings, that is the investigation officer, and the two arrest witnesses, they have been made witnesses in the disciplinary proceedings. Now again, since the charge sheet is yet to be filed, and an accused or the delinquent employee is not entitled in law to an advocate in a disciplinary proceedings, if the petitioner is supposed or is allowed to cross-examine these witnesses, then this will cause prejudice in the criminal trial. Because without the aid of an advocate to prove possession.
You see, there are judgments also that the criminal trial's decision will not affect the disciplinary proceedings.
Yes.
There are judgments
Yes,
also.
but I'm banking on this little exception which has been made on by the Supreme Court.
So I'm not inclined.
Very well.
I'm not
In
inclined.
that case, notice.
So after all these discussions, then should I refer to this judgment? Should I refer to this judgment or no?
It's all right. Okay.
I won't refer. I'll issue notice. Learned Counsel, Mr. L. Iralu is present for the petitioner.
It'll be sometime. I'm for the state.
And learned government advocate. AAG, Mr. L.
LD Sangha.
Sanctum is present for the respondent state. Petitioner to takes it, full stop, this, the petition has been preferred by the, this application has been preferred by the petitioner for to stay.
Yes.
This is the final order this is your prayer to stay the disciplinary proceedings against him as a criminal case, him in the office of the superintendent,
Yes.
Kohima,
Longman.
Longland. Full stop. Or comma, as a criminal case being GR case number 12 of 2025 arising out of Longlang, LONGLEN, women PS case number 001/2025 under section 22 within bracket small a stroke 22 within bracket small b of the NDPS Act is pending against him. Notice to be issued to the respondents, sufficient copies to be furnished. List the matter after 4 weeks, 2 weeks, 4 weeks.
I'm okay.
For motion, item number 2.
The petitioner's land, measuring around 29 acres of land, it was legally occupied this year 1959 by the Assam Rifles.
Mm.
Respondent number 1 to 4.
Mm.
And they have been the continuous occupation of such land.
Mm.
We have approached the authorities on several occasions for
Mm.
payment of rent
Mm.
or execution of listing, or
Mm.
maybe even for premium in terms of the existing rules,
Mm.
notifications, as well as there is also a state
Mm.
legislation,
Mm.
whereas those procedures were not followed at all.
Mm.
We have represented to the authorities on several occasions, we are compared to a constitutional report
Land was acquired for what?
for establishment of their camp, Assam Rifles.
Okay. Okay. Under the new act?
It was occupied in the year 1959,
Oh, long time back.
long time back.
So why is
In
this
fact,
delay?
66 years.
Why this delay?
We have also stated, we have approached the authorities in several occasions. There's also a clear judgment of the Supreme Court for occupation of land,
Yes.
the question of delaying the rights.
Mm.
So there are also judgments where this honorable court given specific direction to the respondents to pay compensation
Mm.
in terms of the accessing the
Mm.
land.
Yes. But when was the last cause of action?
It is a continued course of action because they are occupied since the day one, illegally occupied. Because in terms of the Netherlands, land acquisition requisition act,
When was your first representation?
we have served, the latest representation is dated 22nd March 2025. Before that, also there were representations. We have also made approach them in person.
22nd March, I understand.
Yes.
That was the last one. The first one?
The first one, there's no such report, but
Mm.
we have been approaching them personally.
66 years?
Yes, yes.
Issue notice.
There are clear notifications by the state government as well as the ministry
Mm.
that when the paramilitary forces they occupy land, they should at least exhibit.
Let them obtain instructions. Who is there on the other side? Anybody appearing? Or or you'll have to issue notice, then they will appear.
There are similar cases.
Issued armed forces? Nobody, not appearing. So issue notice.
I'll serve copy with the cities.
CGC,
Yes.
yes. Armed forces, it will be CGC, I think. Learned Counsel, Mr. Mua Jamir is present for the petitioner. Who stop petitioner, learned, you are present for?
For the state.
State Learned Government Advocate, Mr.
And now
M. Longkumar is present for how many respondents?
5, 6, and 7.
Respondent number 5, 6, and 7. Within for the state, comma reply for the state, full stop. Steps to be taken to issue notice to the respondent number 1, 2, 3, 4, and 5, 3 and 4. Full stop. Sufficient copies to be furnished. You want to what? Inform or what? Serve a copy. Sufficient copies to be furnished. Okay. You can serve copy as soon as you want. List after how many weeks? 2 weeks?
3 weeks.
3 weeks. List after 3 weeks.
For admission, item number 3.
Lordship, as per my instruction, the pension is already settled.
Oh, matter is settled. So if he's satisfied, then we can close it.
Item number, serial number 123 in the next page.
The process is fine, that will be in favor of
Sorry,
this is.
can you take the speaker to your
What?
near your mouth? Yes.
What I am saying is,
Uh,
whatever the communication between my learner friend that is accounting general
yes.
in the home department. But
So the petitioner is saying that he's yet to receive, even
Yes,
though
that is
on the
what-
part of the respondent number 5, that is the principal accountant general.
yes,
You do not believe them.
No,
No.
it's
I believe very much
Hmm.
if this petition includes interest on. The prayer is specific in the.
Yes,
petition.
yes.
Because this is an issue which was decided way back on 2011 by this honorable. You just imagine more than 10 years.
Your Lordship,
Then
there
that's
is
This is the name.
interest issue
Sure,
between the
sure.
petitioner and the state respondents.
Yes, I understand that. Not
Lordship.
case my
The department is which department? You have
home
which?
department.
Home department.
Okay.
Home department, Your Lordship. Payment, Your Lordship, as far as payment is.
You want to wait till the payment or what? You want to wait till the, you do not want the matter to be closed now?
No,
Okay.
apart from this, the question will be about the entries
Hmm.
in the course order proceedings.
So now see, they have produced the list and I think your name must be included in the list.
Yes, Your Lordship, it can be seen as serial number 123.
Hmm.
One, two,
As far as the office of the accountant general.
Hmm.
is
When
concerned,
everything is decided, we can wait, no problem. Where is the problem? We can wait. But what is the point of waiting? You are already getting the pension.
no,
You'll be getting.
Yeah, you'll be getting very soon.
yes, that is what the thing I'm saying, see. This also, this petition also is, second petition is filed way back in 2021. In
Earlier it was filed in 2011,
2009,
9,
decided in 2011.
11.
Yes.
But still he or she did not get the
That is
pension.
why.
Okay.
So let them settle it in after that. Your lordship will look into the action of
Okay.
release fund.
Okay.
Let the petitioner is entitled for the interest on it.
This is extraordinary pension. There are some extraordinary pension. There are some criteria to get extraordinary
Yes,
pension.
Your Lordship, as far as the extraordinary pension issue in this case is concerned, that extraordinary pension is now converted into a family pension now, Your Lordship.
Mm.
Why that has happened is because, Your Lordship, the petitioner initially was not a regular employee, and therefore he was not entitled for any family pension.
Yes, yes. This is the reason.
Yeah,
why-
this is the reason why, yes, family pension was not granted.
Mm.
Now, Your Lordship, the government have on the approval of the cabinet.
Yeah, there is a notification.
Yes, yes.
They're
Has-
getting extraordinary pension.
Yes, yes. Now that has been converted into a family pension. So the issue of interest, Your Lordship,
Mm.
we actually have went to be very precise, Your Lordship. We actually have gone a little bit out of the rule book, out of the rule book.
Actually, you
After the-
see, you will get everything. It
Well,
will be
what that
calculated
is-
along with the increase in DA, everything. Everything
Your
will be
Lordship,
included.
everything.
That is
Don't
the
make
interest.
The petitioner give it.
Okay, okay.
Right.
All right. I understand.
And
After movement in the office,
Yeah.
he will close the case.
Yes.
He want the case to be open.
Yes, Your Lordship, only thing is that this Accountant General Office list, this list that
Yes,
the
yes,
Malaysian
yes.
government has presented,
Right.
this list to whom it has been submitted,
Hmm.
there is nothing there, just the list.
Hmm.
So when was it submitted and to whom it has been submitted? Now, who holds the authority to pay?
No, that question, who holds the authority to pay? We are only an approving authority, so the concerned department,
No,
they
I
will
mean
have the
dispersing,
information.
the dispersing, Your Lordship.
It will be dispersed by the office.
Yes, by the office.
By the office.
And
No, Your
then,
Lordship.
Where he was serving.
No, Your Lordship, because pension, I think, have to be dispersed by the treasurer office.
Yes,
Not-
by the treasury, by
Yeah,
the treasury.
Not by the, not by the
Correct, correct.
respondent department.
Yes, yes, by the
So
treasury.
who has it been sent? To whom has it been sent?
There are quotas. Some departments are receiving pension from this departments, from this group. Some departments are receiving. There are different groups.
Yes.
He will know better.
Lordship, as far as my knowledge goes, there are North and South Treasury
Hmm.
where the pensions are being dispersed. So
From the state treasury, I think.
yes, from the state treasury.
I have my learned friends,
Hmm.
the concern that he has.
All the
But
government
that's-
servants are receiving pension from the state treasury, from the state.
Yes, not from the respondent department.
No, no,
Not
no.
from the.
No, but everything will be prepared by the department and be forwarded.
Yes.
Pension papers and everything, I
Yes.
think it has already been prepared and forwarded.
You may have whatever the Accountant General Office.
Mm.
And we have sent to the home department.
Mm.
So, after we send back, it is them again who will process it to the treasury. And the
Mm.
treasury.
I think that is what processing is, waiting for the processing only.
Yes, your lordship.
I'm-
And,
I'm sure
Yes.
after everything is processed, this case, he won't mind the case being closed.
yes, your lordship, and he wants interest, that's why. And
No,
interest.
no.
That is an issue between the.
He knows he won't get interest, but he will get all the arrears and back wages and everything.
Correct. More or less interest only, Your Lordship.
He will get it.
Yes, that will.
Automatically, he will get it.
Yes, automatically.
Whatever is entitled, he is entitled by law, he will get it.
Yes, your lordship.
Not beyond
In
that.
any case, your lordship, if my learned friend is concerned, he can also ask from the home department. I can also ask from the office of the accountant general
Mm.
to ask them on where exactly this file was sent.
Yes.
Mm.
That also I can ask.
Yes, 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 that will be better.
Yes, your lord.
When was the last order? 23/7, 2025?
Yes. Yes.
Okay. 2 weeks time to complete the same. Learned Counsel, Mr. Appearing for the Accountant General response submits that the documents have been received and they are under process and accordingly prayed for 2 weeks time to. Okay. Item number, this is item number. Learned Counsel, Mr. Imti Longshar is present for the petitioner. Learned Government Advocate, Mr. N. Angami is N. Angami, no?
Yes.
Is present for the respondent.
1 to 4.
Number 1 to 4, and Learned Counsel, Mr.
Joshua.
Joshua Sheki is present for respondent.
Number
CGC, no? You are
Standing also.
standing counsel for the AG. Learned Standing Counsel
Yes,
for the AG, Mr. Joshua Sheki is present for respondent number
5.
5.
Five.
The Learned Standing Counsel has produced a copy of the list of pension cases settled during the first and second batch of July 2025, which includes the petitioner's name at serial number 123. It is all who will obtain the instructions as suggested? You have stated, no, you'll whether the process.
Yes.
What is the last submission? Come again, I forgot. You have suggested something.
Your lordship, after the approval of the
Uh.
AG,
Uh,
where was this approval file sent? either to the Home Department or to the Treasury. That instruction, if. a
Okay,
direction may be-
the respondents may obtain instructions relating to the,
Respondent number 3 is the whole.
okay, forwarding.
Respondent number 3.
okay, it's okay. Relating, I'll include it, respond number, I'll correct it.
Look,
Relating to the forwarding of the pension papers. Pension, what?
the approved pension.
Approval of the pension papers. Forwarding of pension papers from
From the AG,
from the AG to the concerned department
yes,
to ascertain to which department the papers were forwarded.
yes. your
Okay. Respondent number 3 to Kati Dipasu. 1, 2, 3. Respondent number 3. Nobody's present for respondent number 3, no?
No, I'm.
Okay, okay. All right. Nalai Kati Nalai. Okay, sir. Okay, list the matter. When do you want? 4 weeks?
One.
Government?
To complete
2 weeks. Government will need some time. Government will need some time. 2 weeks. List the matter after 2 weeks. You see, with the landslide and rain. Okay.
No, it is within
AI. AI.
Walking distance.
And now we have AI also.
We have a lot of traffic jams also. That also gets to.
Yes, yes.
Much better.
So 2 weeks. 2 weeks will be fine, no?
Yes, sir.
I think so.
For admission, item number 11.
Lordship, I have received a letter from the department, so if I may be allowed before the vote open.
Yes, yes.
So Lordship.
Matter is under consideration.
Lordship, here I quoted the prayer, Lordship, to seek permission to conduct verification.
Verification, yes.
Lordship.
For verification, yes.
Next, Lordship.
Hmm.
Lordship is as per the OM. Lordship may come to page 15 of my petition. Petition. The case of the petitioner is that the petitioner is a landowner, and the petitioner has submitted an application for appointment of as a medical attendant in the sub-center. And in view of the land donated by the father of the petitioner, the petitioner should be considered for appointment. So, as per the OM, as per the notification dated 5th March 2018, that is page 13, my lady may come to 3B, the relevant portion of 3B, page 13.
Yes.
If there is any claim for providing employment as a result of the oral agreement, the department concerned shall refer the matter to the deputy commissioner or the district concerned, who shall examine such claim carefully, including whether any employment or any other facility, including contract or supply, order has been given in the past. Written statements from the witness, that is government officials of the concerned department and the district industry and village functioning present at the time of such oral agreement should be taken by the deputy commissioner. The recommendation of the deputy commissioner should be referred with relevant documents to the Department of Land Revenue for advice in such cases by the department. Now the deputy commissioner, well, as per this letter dated 28th June 2025, was intimated by the learned government advocate, stating that since the petitioners is challenging the appointment of the respondent number 4, is a challenge. So the appointment is at the page 28. What the petitioner is
You're challenging this appointment.
Yes, saying that this person is not a landowner.
Hmm.
So if at the stage, if this, the government wants to take up a verification, then Lordship can, quash this appointment and, direct the respondent to take up the verification at this stage. Because it won't be fair where the respondent is in service and the verification will be conducted. So that it will be fair on the part of the petitioner. The respondent is working in the,
I know he's working,
Yes.
he or she is working. So,
without,
so
any-
suddenly, how can I quash?
Yes, Lordship, Lordship.
Suddenly,
Yes.
so during the
let
pendency.
them verify. If the
Lordship,
documents are found to be false, then definitely I'll quash it.
So, Lordship, in that case, Your Honor, my lady, I have a prayer, interim prayer to stay the appointment of
He's
the,
already working. Is he working, drawing salary? You know, do not know, no?
No.
Respond number 4, is he working?
Lordship,
He is already appointed.
I don't know if it's structured.
Is there any stake? Is there any stay earlier?
no stay. I've pressed, but since,
Now, since when was he appointed?
what, my lady, one submitting is,
When was he appointed, he or she?
it's he, which is
Page,
28,
page
and
20,
7,
page 28.
and actually 7.
December 2024. I think must be working.
Yes.
So suddenly how can I stay?
No. Now the government wants to verify. So verification.
Let them verify.
Lordship, yes.
Let them verify and obtain instructions.
What the petitioner, Lordship, all submitting is, it wouldn't be fair when the respondent appointment is under challenge and he is working and verification is conducted. That is why. If
It is you who are saying that he is not a landowner, but he
No.
may be. Let them verify. He may be. Do you have solid proof that he is not a landowner? Why will they appoint if he is not a landowner?
Even otherwise, my lady, I want to point out to the same notification dated 13.
13.
On 5th March 2018, page 13.
Yes.
My lady may come to 3C. 3C.
Yes.
It is also clarified that it's not the policy of the government to provide employment to the landowner in perpetuity. Even though if he's a landowner, his father was working as medical attendant in the same sub-center. After his retirement, he was appointed.
Okay.
That is why.
You have valid grounds.
Yes. So even if this Honorable Court wants to proceed with this and grant permission to verify the appointment of the respondent 4 should be stayed. Because it wouldn't be fair.
His father was working in the department.
Yes, his father was working, and now.
That is what they want to verify, I think.
Yes. So, Lordship my lady may stay the appointment in the stage and go ahead with the verification because it will be fair.
No.
That's my only prayer.
I'm sorry. No.
Or
Won't
pass an order.
stay. Maybe final order will be in your favor, but
Yes.
now at least I won't stay.
So pass an order that it will be outcome of the verification. The
No,
appointment of the.
No. Let him work. Let him work. Suddenly, staying will not be justified. Verification is going on. If it is found,
Yes, yes.
then if you do not agree to it, we'll hear the arguments and finally, if it is fit to be quashed, definitely we'll quash.
Yeah.
We already have the notification that in perpetuity you cannot continue to be appointed as a landowner one after the other. There are other families also who have donated land.
Yes, ma'am.
Without other families donating their land, how can you establish a department?
Yes, ma'am. My lady, in that view, as per this Honorable Court's order dated 2/6/2025, the Honorable Court was pleased to direct the petitioner to take steps upon respondent 4. And after taking steps by way of data service and I find my affidavit. So if the service upon respondent number 4 is deemed to be complete, I
Okay.
find my affidavit.
All right.
Dated
It will
dated
be
15th of July.
deemed to be served, sure.
Yes.
15 July,
In July. I filed an affidavit.
18 July.
15, yes.
18 July, we do not have 18 July's
In July,
affidavit.
July.
No,
July, one affidavit.
it's not on record.
Affidavit of service.
It's not on record.
Affidavit
Oh,
of
yes,
service.
yes, we have, I think. We have.
Affidavit of service, yes.
Yes. Affidavit of
Fine.
service, yes,
Yes.
we have.
I didn't see a page
Respondent
4.
number 4, okay,
Yes.
deemed to be
Affidavit
served.
of service.
Learned Counsel Mr. P. Forte is present for the petitioner. Learned Government Advocate Ms. Pichano
Lordship.
is present for the respondent number 1, 2,
One,
3.
1 to 4, Lordship.
1,
three.
no, not 4, I think.
Four,
1, 2,
right,
1, 2, and
Oh,
3.
one-
Full stop. The learned government advocate has submitted. This is a copy, you know,
Lordship.
a copy of the letter forwarded by Director HOD, Health and Family Welfare, Nagaland, Kohima, wherein it is reflected that the matter involved in the instant writ petition is for consideration of appointment on land ownership basis, and therefore permission may be sought from this court for issuing a direction for verification by the concerned deputy commissioner in terms of the existing state government policy. Full stop. The learned counsel for the petitioner has submitted that in case a verification is sought, the appointment of respondent number 4 may be stayed,
Maybe stay washed.
maybe stayed or quashed.
Maybe washed or stay. That was my assumption.
So we want direct verification then.
Yes, Lordship.
We want direct verification.
Lordship,
My lady,
Hmm.
may direct to the DC for verification, Lordship.
Okay.
In terms of the notification, the 5 March 2018, 3B,
Okay, a verified report may be submitted by the DC.
Lordship.
All right. All right. A verified report may be submitted by the DC relating to the appointment of respondent number 4. All right.
verification of the land,
Uh,
where the present.
verification of the land, yes, may be submitted by the DC relating to the respondent number 4. And if anything else to be verified,
No, now the verification.
remaining part you will prove.
Yes.
Or that he was appointed in perpetuity. That remaining part you will prove. All right.
Yes.
Okay.
My lady, the verification is in respect of the land donated either
Mm.
since either by the respondent or the petitioner at Shinga Mokot Sub-Center.
A verification of the land donated by the either by the petitioner or by the DC or
By the-
either by the respondent number 4 may be submitted by the DC within
Lordship, 1 month, Lordship. It may-
within 1 month. Stop. The
Lordship, after 1 month, it will take some time. but after
Let it be
1
after 4 weeks and let it be.
after 4 weeks. After
Yeah,
4
if you
weeks.
want, the government wants to support time.
After 4 weeks. Meanwhile, oh, not meanwhile, no, not stack of the meanwhile word. The learned counsel for the petitioner has submitted an affidavit of service to the respondent number 4. stop the service report routed through dusty service is appended along with the affidavit. What is his name? Respondent number 4's name?
Gan Konyak. Medical attendant, Chinamo, Subcenter District, more. And email, turn to page 4 of the affidavit. The series, the particles are there. To so and so to Mr. Klein and come back. But the service of understanding for me within the government.
Which has been received by the petitioner, by the respondent number 4.
Yes. And even witnessed by.
Annexure 1 is the annexure 1 is the notice returned on receipt of service. Full stop. Notice is hereby deemed to be served. List the matter, list accordingly. List the matter after 4 weeks.
For hearing, item number 18.
Yes, yes.
Sorry for indulgence.
Yes, yes.
Number 19 and 20.
Ah,
It appears like the CGC who is appearing is
ah,
he's on leave.
okay, okay.
Just
Okay, I have not checked. Item number 19 and 20, no? Learned CGC, Mr. Younger Wati is on leave. Item number 19 and 20, huh? Learned counsel for the petitioner, Mr. Muaz Emini is present. List the matter after 1 week, 2 week.
18. The consensus prayer.
Okay. Also include learned government advocate, Miss S. Mary is also present for the respondent number,
For the state respondent.
for the state respondents. Okay, you want a date or
18.
18th? List the matter on 18th August. All right. Yes, yes. 1920, no? Oh. This is item number 18. All right, all right.
May I please, Your Lordship?
Mm.
Your Lordship, by this instant writ petition, the petitioners are praying for regularization of their respective services to 6 drivers' position that arose by virtue of retirement promotion within the department, my lord. Your Lordship, all the 6 writ petitioners here are the senior-most contingency fixed drivers who came to be appointed between the year 2009 to 2012, employed with the department.
2009 to?
2009 to 2012.
Okay.
Yes, Your Lordship. Employed with the Department of Treasuries and Accounts, Nagaland, Kohima, my lord. They have been serving diligently with the department for the last 13 to 18 years. And Your Lordship, despite their classification as contingent drivers, they have been consistently executing their duties with the same dedication, proficiency, and accountability as their regular counterparts, Your Lordship. My lord, during the year 2019 to 2021, Your Lordship, a total of 6 posts was vacated in the respondent department by way of promotion and retirement, which remained unfilled till date, Your Lordship.
6 posts.
Yes,
posts.
Your Lordship, which is remaining unfilled till date, Your Lordship. And additionally, more vacancies have been identified. But I will bring Your Lordship to that later on, my lord. So, Your Lordship, for obtaining specific information regarding contingent fixed drivers, RTA was also filed. The details of this RTA is contained in my Annexure 7, Your Lordship, page number 23 of my writ petition, my lord. So this is the RTA filed to the PIO, Department of Treasuries and Accounts.
Annexure 7, page number?
23, Your Lordship. And now, Your Lordship, I would like to point out particularly serial number 6 and 7.
Serial number 6 and 7, okay?
Yes, Your Lordship. Query number 6 is required number of sanctioned posts of driver. Query number 7, nature and duties performed by a regular and.
Page number
drivers.
23.
Yes, Your Lordship. This is the RTI application filed, Your Lordship, by the counsel of the petitioner, Your Lordship.
Just a moment, let me see. page 23 of the WPC.
Yes, 23 of the writ petition, main writ petition.
Okay, I got it. Yes.
And your lordship,
Yes,
in
yes.
reply to this RTI, your lordship.
Mm.
Next page, page 24, and extra 8, your lordship. Dated 14th of September 2017. I would like to take your lordship to the relevant page, your lordship, page number 25. Reply, that is, reply to query number 6 and 7, my lord.
Mm. Okay.
The query number 6, your lordship. Number of sanction posts of driver required is 54, my lord.
Mm.
And additionally, this query number 7, natures and duties performed by regular and fixed, the same duties as per their driving licenses, my lord.
Mm.
So, your lordship, the respondents have stated that both fixed and regular drivers perform the same duties as per their driving licenses, your lordship. So now, since both regular and fixed drivers perform the same duties as per the respondents on reply, your lordship, it is just fair the fixed drivers are given opportunity comparable to the regular drivers, your lordship. Now, your lordship, I would like to take you to my annexure 9, page 26. This is the formal proposal for regularization of the petitioners to the post of drivers, written by the Principal Director of the Respondent Department to the Additional Chief Secretary and Finance Commissioner Nagaland, Kohima, your lordship, seeking for approval of the regularization against the resulting vacancy of retirement caused by retirement promotion, my lord. Next page, your lordship, annexure 10, page number 27. This tableau chart is the statement showing the names of fixed paid drivers for regularization against retirement/promotion. So under the column of the regularization against whom, your lordship, these 6 employees specifically highlights that who have already been retired and promoted, your lordship. And under the column of the name of the fixed paid drivers, your lordship, the details of the 6 present with petitioners, names of the petitioners proposing for regularization against retirement promotion, your lordship.
Okay.
And your lordship, again, your lordship, with in reference to this office letter, your lordship, another proposal was sent to the government, your lordship, annexure 12, page 30.
So these are the petitioners' names
Yes, your lordship.
for regularization.
Yes, your lordship.
Annexure 12, yes.
May I read, my lord? Letter dated 20th of May 2022, the Government of Nagaland, Directorate of Treasuries and Accounts, Nagaland, Kohima, to the Additional Chief Secretary and Finance Commissioner, Nagaland, Kohima, subject proposal for service regularization to the post of driver. Sir, with reference to this office letter of even number dated 16/7/2021, on the subject cited above, I have the honor to resubmit herewith a proposal for service regularization in respect of 6 fixed paid drivers in seniority order at annexure A enclosed in the pay matrix level of such and such against the resulting vacancy on retirement promotion under the Directorate of Treasuries and Accounts, Nagaland, Kohima. As per the court verdict number WBC number 174K of 2013, dated 17/11/2014, the fixed paid drivers are given an opportunity for regularization after service on seniority basis. In the meantime, the department is facing acute shortage of drivers, creating hindrances for carrying out official duties. Point to be noted, my lord. Now, therefore, the government is requested kindly to convey necessary decision at the earliest. Respectfully, the Principal Director, my lord. So here, your lordship, the respondent has accorded its concurrence with the findings that the direction of this honorable court is clear, your lordship. That your lordship, opportunity should be given for regularization after service on seniority basis, my lord. And also, the department has openly considered to the existence of an acute shortage of drivers, my lord. So therefore, given the department's on concession, it is fair and justified that the petitioner services should be regularized, my lord. With regard to the WBC number 174K of 2013, my lord. The court order is annexed at annexed to 13, page number 32, your lordship. So, your lordship, in this here, your lordship, petitioners who were serving under the same department, that is the Department of Director and Treasurers, your lordship, accounts and treasurers, your lordship. The fixed paid drivers were regularized in compliance of this honorable court's direction in the absence of the rules, my lord.
At that time, the rules were not framed.
Yes, your lordship. The relevant paragraph, your lordship, page number 35. Last third paragraph, I'm reading from there, your lordship.
Okay.
In view of the above, the writ petition is disposed of with direction to the state respondents to consider the case of the petitioner for regularization and thereafter make appointment to the 7 vacant post of drivers that was created by notification dated 28/9/2012, strictly in conformity with the seniority maintained in the department. The impugned officer such is set aside and quashed in so far as it relates to the approval for appointment to the post of drivers in the Department of Treasurers and Accounts. With the above observation and direction, this petition is disposed of. And your lordship, with regard to this, the petitioner has also represented, my lord. Represented to the Finance Commission as well as the Principal Director, Director of Treasurers and Accounts, annexed to 11, page number 28.
This is the representation.
Yes, your lordship. Representation dated 21 to 2022.
Okay. Okay.
Now, your lordship, this representation is also not considered till date. Now, I would like to bring your lordship to my annexure 14, that is office memorandum dated 22nd of September 2004. This is the office memorandum. There's policy and
Page
36, annexure 14.
Okay.
Policy and scheme for regularization of service of work charge employees, your lordship.
Okay.
Here, your lordship, clause 4, your lordship. Work charge.
Yes.
Work charged employees will have the right to be considered first for regularization against 50% of all future vacancies of similar nature in the department for which they possess the requisite qualification. Such regularization will be considered on the basis of seniority cum merit. This means that the senior-most work charge employee in the relevant category will be regularized subject to his or her fitness for the vacant post. And your lordship, coming to again my annexure 15, page 38. That is office memorandum dated 17th of March 2015. Scheme for regularization and absorption of work charged and casual employees. Revision of pay wages, your lordship. Here, the petitioner is covered by clause 1, bracket 3, your lordship. Bracket 3. The existing scheme for regularization of work charge employees against normal vacancy is being modified, and the quota for work charge employees stands enhanced from 50% to 67% for the next
Clause
5
1,
years.
where? Clause 1?
Bracket 3. Page 39.
Okay. Clause 1, yes.
Yes.
Page 39. Okay,
Yes.
I got it.
May I read again?
Yes.
The existing scheme for regularization of work charged employees against normal vacancy is being modified, and the quota for work charged employees stands enhanced from 50% to 67% for the next 5 years, effective from 1/1/2015. This existing scheme will be applicable for the casual employees appointed on full-time basis. Now, your lordship, I would like to take you to my additional affidavit, which I filed on 24/9/2024.
Okay.
Earlier, I was pointing
Mm.
about those vacant, no, 8 vacant, there are again, 8 vacant posts is still lying vacant, your lordship.
Mm.
May I read my paragraph? to
Yes,
your
sir.
lordship? That while pending disposal of the said petition, the petitioners promptly submits that again as many as 8 posts of drivers is lying vacant under the Department of Treasures and Accounts, retired on various dates as shown below. So this tabular chart is prepared, your lordship, showing those 8 employees who have been retired, your lordship, in the post of driver.
Where? Paragraph what?
Page number 4, paragraph 2 of my additional
Okay,
affidavit.
okay, paragraph 2.
Yes.
Okay. I was looking at paragraph 3.
So your lordship, now total comes to 14 vacant posts, your lordship, still that line vacant, your lordship.
Mm.
This, the retirement order of this 8 retired employees have been annexed annexure 17 to 17F, that is page number 7 to 13 of the additional affidavit.
Page 13 of additional affidavit. Okay. All right.
Page 7 to 13.
Hmm?
7 to 13.
Page 7 to 13.
Yes. Released order of all those retired.
Okay, okay.
Yes.
Page 7 to 13.
Yes, your lordship.
Okay.
Now, your lordship, I also filed another additional affidavit. Filed on 29/5/2025.
One more, just a moment.
Lordship.
Page 7 to how many pages? 13. Okay. Now?
Yes,
Another
yes,
additional.
additional affidavit, which I filed on 29th of May 2025.
Oh, I have this. This is 29. This is 2 May. 2 May 2025.
29/5/2025.
29. Okay.
The reason
Alright.
why I filed this additional affidavit is because, your lordship, here, these 6 petitioners, your lordship, along with 7 others, they filed a petition before this honorable court, that is WBC number 130 of 2024. I have annexed in my annexure 18, page number 8, your lordship. So here, your lordship, all these 6 petitioners, your lordship, including those 17 others, your lordship, were directed to pay minimum scale of pay, which is paid to the regular drivers and or bus conductors, your lordship. So now, your lordship, this, by the direction of this honorable court, your lordship, now the case of the petitioners are under process for payment of the scale of pay, my lord. For granting of the minimum scale of pay, my lord.
WPC number 130 of 2022.
Yes, 130 of
Okay.
2022.
All right.
And secondly, my lord, while pending disposal of this writ petition, your lordship, office memorandum dated 5th of March 2025. Page number 25, annexure 19, my lord. This notification was issued by the government, where it has been explicitly stipulated that all work charge and casual employees in all the departments.
It is annexure 20, I think,
Annexure 19, my lord,
Mm.
annexure 19, page 25, your lordship.
24. Page 24, annexure 19. Office OM number AR3, 5th of March 2025. There are two
Yes. we have
annexures.
to-
One is the order and one is the notification. I have gone through this, yes. One is the
Yeah.
order and one is the notification. That before 2016,
Yes.
all have to be
Yes, my lord.
regularized.
Yes, so now I'm fully covered by this notification also. Since all these 6 petitioners were appointed before 2016, your lordship. And then their names have also been registered in PIMS, your lordship.
They were appointed?
Prior to 2016, all the writ petitioners, your
Okay.
lordship.
All right. Yes, you are covered.
So if
Yes.
this notification covers, then I will be covered by Office Memorandum 2015, your lordship.
Mm.
Solely covered, your lordship.
Yes, yes.
The petitioners' PIMS have been registered, my paragraph 3, your lordship,
Mm.
paragraph 3. I have prepared a tabular chart, your lordship.
Mm.
Here, all the PIMS code of the petitioners have been made, your lordship.
Mm.
Paragraph 3, page 5.
Yes. PIMS code.
Yes, your
Okay.
lordship. These are the PIMS code of the petitioners, your
Mm.
lordship.
Okay.
Now, your lordship, I would like to bring your lordship again to the counter file by the state respondents for respondent number 1, 2, 3, and 4.
One, 2, 3, and 4.
Yes, counter affidavit.
Okay. Yes.
Your lordship, the state respondent have stated in paragraph 5, your lordship.
Mm.
It is also pertinent, Mary, my lord.
Yes.
I'm reading from the last bit.
Mm.
It is also pertinent to state hearing that the petitioners are appointed on contingency fixed paid employees, that there is no government standing order stating that all the vacancies in respect of grade 4 employees in a department should be filled by way of regularizing the contingency fixed paid employees, and therefore.
No, this
the-
was filed in 2023.
Yes, your lordship.
But you have the new
Yes, your
notification now?
lordship. Now it's
Huh?
covered.
Rightly pointed out, since
Mm.
they have also annexed in the additional affidavit
Mm.
regarding this office memorandum dated 5 March
Mm.
2025.
Mm.
That squarely covers the.
Squarely covers the case of the
So,
petitioners.
No need to go into
All these details.
logic.
Yes.
She has laboriously toiled. Such a what to say, good argument.
Logic.
Laboriously
So
toiled.
this is squarely covered by this
Mm.
office memorandum.
Mm.
Yes, so now since there are 14 posts vacant, so 6 posts should be given to the petitioners, your lordship. That's my only prayer, your lordship.
Lordship, if we go by this office memorandum dated 5 March 2025,
Mm.
which clearly state conversion of work charge, wage of work charge and casual
Mm.
employees to the scale of the lordship. Here is a case where the petitioner has been appointed on casual employment,
Mm.
contingency fixed pay casual.
Yes, yes.
So their conversion will be that of scale pay,
Mm.
not as a regular. Thereafter, after the scale pay, lordship is well aware, after getting the scale pay, they will definitely automatically will be regularized lordship.
Mm.
So lordship, they are covered by this 5th March 2025 lordship.
Mm. Yes.
Your lordship, without even granting the scale of pay, this honorable court has already decided in Bentang Temjen's case status, I have.
Yes, yes,
Yes.
yes.
So lordship.
For
the-
regularization.
Yes, your lordship.
Lordship, as the petitioner has rightly pointed out that there is no scheme as such for granting of regularization, Lordship. Even if you go by
No, but that, what about the notification?
Lordship,
That latest notification?
that latest notification which talks about only for work charge casual employments to the scale of pay, conversion to the scale of pay.
Oh, okay.
And where
No, not to
we have-
regularize.
Lordship, in fact, we have this scheme,
Hmm.
work charge and casual employments regulation act 2001.
Hmm.
We have that act, Lordship. If I may,
Hmm. She is also given, I think.
no,
No, no.
this is the act. Work charge casual employees act.
Shall be eligible for the provisions as notified under the provisions of the act.
So
Okay.
why now, affidavit, we have stated that
Shall be eligible for regularization. Shall be eligible for the schemes of provisions, not really, okay. The provisions of the act. This is the notification, this is the order.
Lordship,
Shall get a scale of pay, okay.
scale of
Not regularization,
Scale of pay.
Okay.
they are covered by the scale of pay.
Hmm.
We have this.
Which one? This
work
act?
charge,
Hmm.
the Nagaland Work Charge and Casual Employment Regulation Act,
Hmm.
2001.
Hmm.
Lordship, we kindly come to the second page, Lordship. Definition two definition.
You are for respondent number 1 to 4.
1 to 4, Lordship, for all the official respondents.
Hmm.
So why in our affidavit we have stated that there is no
But her prayer is for regularization.
her prayers for regularization, Lordship.
Mm.
However, Lordship, as if we go by this office memorandum of 5 March 2025, it talks about conversion of work charge, wages of work charge and casual employees to the scale of pay, Lordship. Lordship, here is a case where the petitioner are all appointed under the fixed pay contingency, Lordship.
Hmm.
So the next
Yes. Next step.
is that of granting scale of pay, Lordship.
Hmm.
Thereafter, Lordship, after serving for some few years, Lordship, they will be
Regularized.
regularized, Lordship. So that this is the office memorandum, Lordship.
Hmm.
So it is squarely covered by this,
Hmm.
but not the office member, the other notification, Lordship. Notification which talks about inclusion of contingency fixed and wage employees as casual employees under the National Nagaland Work Charge and Casual Employees Regulation Act 2001, Lordship. If you go by this Work Charge Regulation Act, Lordship, I have given you the copy.
Yes.
Lordship, the second page, it talks about the definition.
Hmm.
And in the definition, 2C is
Hmm.
it says that casual employees means an employee engaged without sanction post, Lordship. And D also state that work charge employees means an employee engaged without sanction post under work charge establishment, Lordship.
Hmm.
In the definition, it only talks about work charge engaged without sanction post, Lordship. They are engaged without a sanction post, Lordship. So, Lordship, at this stage, Lordship, since they are covered by this 5 March 2025, Lordship, I have no issue if Lordship may pass a similar order on this, basing on the office memorandum dated 5 March 2025.
Hmm.
That is my submission.
They are already getting scale of pay.
Lordship. Lordship, as of now, they are in fixed pay, contingency fixed.
But their scale of pay is
Covered by
being,
that order, your lordship.
Judgment and order.
Yes, your lordship, 130 of 2024.
they are already getting scale of pay. I think they're getting or they'll be getting
No,
And it's under process, your lordship.
under process.
So definitely they will be getting scale, your lordship.
So this notification, the employees so verified, a verification of such employees shall be conducted on the direction of the Work Charge and Casual Employees Commission. The employees so verified shall be eligible for regularization under clause 1 of the scheme for regularization. and absorption of work charge and casual employees and division of wages according to the notification of 2015.
Lordship, as far as if Lordship may kindly come to page 38 of the writ petition, Lordship.
Okay.
38 of the writ petition, Annex 15, Lordship. Lordship, here the office memorandum talks about all those work charge and casual employees of various departments who are enjoying scale of pay and who have completed 30 years.
Oh, yes, yes. Yes, 30
Only
years. Or who will be completing 30
those
years.
will be completing 30 years. Only those are eligible for regularization.
Mm.
So they are not coming under that privilege.
Where is it? OM 2015?
OM 2000.
Page 38, where is it?
One clause one sub clause one. So one. Regularization in service. All existing work charge and casual employees of various departments who are enjoying scale pay and who have completed 30 years or more continuous service as on 1/1/2015 will be regularized by conversion of the posts into regular ones personal to them and subject to the fulfillment of the conditions as indicated below. And it is also mentioned Roman 3. Roman 3 is state that page 39. It states that the existing scheme for regularization of work charge employees against normal vacancy is being modified and the quota for work charge employees stand enhanced from 50% to 67% for the next 5 years, effective from 1/1/2015. This existing scheme will also be applicable for the casual employees appointed on the full-time basis. But they are not coming in this. They are not covered by this office memorandum voucher. In fact, they are covered by this. They have annexed in their additional affidavit, page 25. They are covered by this. Since they have not completed 30 years, and more so, they are on contingency fixed employed. So they don't come under the purview of this office memorandum.
My Lordship, with regard to this 17th of March 2015, there are two types of work charge, Your Lordship, regularization for work charge. Now, clause 1, bracket 1, Your Lordship, all work charge existing, work charge and casual employees of various departments who are enjoying scale of pay and who have completed 30 years. I'm not into that, Your Lordship. I'm into clause number 3, Your Lordship. Existing scheme for regularization of work charge employees against normal vacancies being modified, and the quota for work charge employees stands enhanced from 50% to 67% for the next 5 years. So counting from 2015 to 2021, now that covers 5 years, Your Lordship. So now what I'm seeking from this honorable court is that there are 14 posts, Your Lordship. So with regard to 50-50, Your Lordship, 7 posts should be reserved to me, Your Lordship, on the basis of seniority. That's what I'm praying, Your Lordship. One is for regularization, that is after completing 30 years, Your Lordship. And the other one is quota reserved on seniority basis, Your Lordship, for regularization. That's the only difference, Your Lordship.
Yes. After 5 years, 14-year posts are vacant.
Lordship, that has to be a certain lordship since I have filed our affidavit in opposition on 2020.
Your Lordship, this is an official order, Your Lordship.
What do you have to ascertain? I don't think so. This is clear only.
Lordship, that I leave to your lordship, but basing on this office memorandum, lordship. They have also annexed, they are covered by 5 March 2025 lordship, office memorandum, not the.
They are covered, but that is not their prayer. They are already being considered for scale of pay. So they are asking for regularization, and then see the existing scheme for regularization of work charge employees against normal vacancies being modified. It has been modified, this existing scheme. Then the quota for work charge employees stands enhanced from 50 to 67% for the next 5 years with effect from 1/1/2015. This scheme will also be applicable for the casual employees appointed on full-time basis. So they are not appointed on full-time basis.
They are not appointed, that's what I'm saying.
Okay.
That's what I'm saying, they are not appointed as a full-time basis lordship. Lordship,
With regard to that, your lordship, I have pointed out in my RTI, your lordship, the respondents have clearly stated that your lordship, both fixed and regular employees, they are performing similar nature and duties, your lordship.
lordship may kindly come to the page 14, lordship. Page 14 of the writ petition. And next year, starting from next year 1, that they have annexed.
Page
all
14.
Page 14.
40.
14 of the writ petition.
14, okay. Yes.
Lordship, this is the order, appointment order. That is 2010, the type copy is at page 15, lordship. Here it stated in a partial modification of this office order, so Sri so-and-so, the petitioner, son of so-and-so, is hereby appointed as fixed paid driver at the rate of rupees 3,000 only per month for the period of 6 months with immediate effect, lordship. They were appointed on a fixed pay, lordship.
Okay.
So they are not a full-time employee, lordship. And all the other petitioner, they have also annexed, lordship. And lordship may also come to the page 20, lordship, which they have annexed. That is in continuation of the earlier order. Page 20.
Page 20.
Page 20, annexure 5. Here also, lordship. Page 20, annexure 5. This is dated 1 Feb 2012.
Okay.
Here, the chart, serial number 1, Sri so-and-so, driver, monthly wage, 3,000 per month. Less of posting, PTA, Kohima, lordship. So they are all on the contingency fixed employee, lordship.
So according to the RTI reply, at which page
Page, relevant page is page 25, your lordship.
of this?
Yes, a repetition of the main repetition, your lordship. The query number 7, that is nature and duties performed by regular and fixed drivers, is that they are performing the same duties as per their driving license, both regular and fixed, your lordship. Query number 7, your lordship.
So as per the driving license, what do they mean? I cannot follow. As per the driving license. What is in their driving license? As per the driving license, as drivers.
That, yes, your lordship, that will be covered by the WPC 130 of 2024. I'll bring your lordship. Additional affidavit filed on 29th of May 2025, 29th by
WPC 130 of
2022.
Additional affidavit?
Filed on 29/5, 2025.
29/5,
Yes.
no? Okay.
Court order is at page 8 and extra 18, your lordship.
Page?
8 and extra 18.
Yes, yes.
Here the petitioner number 4 in the read petition is serial at number 1, your lordship. Alamba Jamia.
Mm.
And petitioner number 2 is serial at
Petitioner number?
2. Petitioner number 4 is serial at number 1. Alamba Jamia.
Serial number
1.
1.
Yes.
Mm.
And petitioner number 2 serial at serial number 2.
Mm.
Figure that's serial number 2.
Mm.
Serial number 8 is petitioner number 5.
Mm.
Serial number 8, petitioner number 5.
Mm.
Serial number 17, petitioner number 3. And serial number 18 is petitioner number 1.
Mm. Okay. So in this judgment, their case is covered,
Yes, your lordship.
that they are, this will explain that as per the driving license.
Yes, your lordship.
Which paragraph?
Page 35 of the read. Page 35. What is in the sun?
Page 35?
Page 25. Regular and fixed driver performs the same duty as per their drive. Page 25, wording of the sub of the requisition.
Your lordship, I would like to take you to the relevant paragraph only. Paragraph number 38, your lordship.
Mm.
Page number 24 of the judgment order, your lordship.
Okay.
In view of the discussions, made above, and in the light of the law laid down by the Honorable Supreme Court, this court has no hesitation in holding that the petitioners who discharges the same nature of work and duties as that of the regular drivers, bus conductors in sanctioned posts are entitled to pay parity on the scale of equal pay for equal work. It does not talk about the driving license, your lordship, but it talks about the
Equal
nature
pay
of
for equal work.
duties and functions, your lordship. Yes, your lordship. So they are performing like any other regular employees, your lordship. That's what I want to point it out.
Yes, she has a point.
And read the logic.
Okay.
That is a part of the report. I can ask.
No, she has a point.
So my only prayer is about the 14 post, the 50-50, your lordship. 7 posts should be reserved for the 6 posts should be reserved for the petitioners for regularization of their service. That's my only prayer, your lordship. And direction should be given to the respondents.
This is the last, or? Huh? There are 4 hearing matters. Anybody is present here now? Okay. Is it urgent? Urgent? Okay. Reserved then. Otherwise, I could have passed the order today, but if reserved, then I don't know, till 3 months, I don't know. I'll try to dispose it before 3 months.
Lord, much obliged, my lord.
Hard learned counsel, miss,
Alright, like this.
and learn for the petitioner and learned government advocate senior, learned government advocate Mr. Bhijimomi for the respondents.
All those.
For the respondents, no? for the respondents, reserved for judgment and order. I'll try to, because this is very short matter, I'll try to dispose it of within 2-3 days, but I'll have to take the record with me.
Lordship.
Before I forget the story, I'll try to dispose.
Yes, Lordship.
Otherwise we'll forget the story and again we'll have to,
Come back.
yes, get deep into it and
Yes.
try to recall whatever they have submitted.
Obliged, my lord.
For hearing, item number 26.
Yes.
Lordship, though the writ petition is thick due to the duplication of records, in essence, it's a very simple writ petition. Now, I would like to take my lord straight away to annexure 2
Page,
of the writ petition, page 45. This is the appointment order of the petitioner number 1.
okay.
Similar identical appointment orders have been issued on various dates in the month of September 2023 with the rest of the petitioners, which I have all annexed in this writ petition. Now, if I may be allowed to read.
Continuously from annexure 3, 4,
Annexure,
5.
yes,
All the other petitioners' appointments order.
yes, yes.
Up to
Annexure 2 to 73 are all appointment orders of the petitioners. There are 72 petitioners here.
thereafter.
Now,
Annexure 2 to annexure, how much?
2 to 73. 2 to 73 are all appointment orders.
Okay.
Now I may be allowed to read. This is important. Page 45, my lord. Dated so and so, consequent upon the approval of the government-wide letter number so and so, dated 19 October 2022, and PNAR department, OM number so and so, dated 3/10/2022, Srimati so and so is hereby appointed as operation and maintenance staff in the scale pay of rupees so and so, with grade pay of rupees 1,300 plus all other allowances as are admissible under the rules enforced from time to time with effect from 15/9/2023 and posted under the executive engineer PhD Tuensang division under the following service conditions. Now this is important. 1. The appointees shall be on probation for 2 years. On completion of the probation period, all the appointees shall be subjected to suitability test. This suitability test shall be conducted at divisional level and the division shall maintain the seniority based on merit. 2. Only those O&M staff who qualify the suitability test shall be eligible to be considered for regularization against vacant sanction posts based on the merit list division-wise. 3. Other conditions of service shall be governed by the relevant rules, orders issued from time to time. Now, on this service conditions, that 2 years probation, and after that, suitability test will be conducted. If they fail in that particular test, then of course they will not continue in the employment of the state. Now, very arbitrarily, if I may take my lord to annexure 74.
Page.
I may be allowed to. Page 129. Now, annexures 74 to 144 are identical annexures. In that sense, these are all termination orders passed by the state respondents.
Annexure 74 to annexure 200
144, 74 to
Okay.
144.
Okay.
In pursuance,
Hmm.
129, I may be allowed to read the body.
Okay.
This was passed in February
23rd, 2024. That is, now I'm about to read the relevant portion. In pursuance to PNR Department, Office Memorandum Number so and so, dated 3/10/2022, and Government Approval Number so and so, dated 19 October 2022. And in order to keep the O&M staff within the ceiling limit fixed by the Government Department in the interest of public service, with regret would like to inform you that your appointment by Office Order Number so and so is hereby terminated. Therefore, please be advised to consider this as 1 month's notice, and your services will be terminated with effect from 1/4/2024. Now, whereas the only reason that they have given here is that in order to maintain the ceiling, that is, the ceiling may be 2,000, it may be 3,000, 2,000 and something. Now, the reason given by the state respondents is that there is excess appointment. However, as per the appointment orders issued, they are only serving on probation basis, and a suitability test is to be conducted. After completion of the probation period, let them sit in the suitability test. If they are found suitable by the department.
Suitability test was not conducted.
No, because we were not allowed to complete the 2 years probation. Without completion of the 2 years probation, we were terminated.
Yes. That is what I have noticed also.
Yes. Now, we have made a representation to the state government also, which I have annexed Annex 146 to my revision. This at page 215 to 218.
Page 215
to 218.
Okay. All together have made the representation.
No, in order to avoid duplication, I have annexed this one, and I have given a statement that the
Others have also made.
others have also submitted, and if required, the records may be placed by the state respondents before this honorable court. Now, there is no dispute to the fact that these representations have been submitted, because they have also filed, the state has also filed a counter affidavit before this honorable court. Now, this representation has also not been considered. That is my point. Now, again, I have filed an RTI application before the department.
All the 74 petitioners have filed
Yes.
RTA application.
Yeah. Yes, yes.
So I'll write, we have filed RTA application.
RTI application, yes. It has been filed through one person
Okay.
known to the petitioners, and the list of appointments made since October 2022 in the respondent department has been asked, has been requested, and they have furnished the information.
Where's the RTA application?
220. The information that I have received.
Page 220 is the RTA application.
RTI information that was furnished to me. The RTI reply, because the reply, only the reply is important. So I have annexed the reply in the instant writ petition, starting from page number 147, which is the covering letter.
219.
219, the last annexure of the petition.
Okay. 219, yes.
Now, query number 3, total number of WC staff regularized under the 2015 scheme. Query number 1, monthly vacancies of O&M staff with effect from October 2022 to 31st March 2024. So if my lord may kindly go to page 220.
Page 220, yes.
My lord, if the relevant page may be perused. Serial number 1, October 2022, ceiling 2000, existing 1,156, vacancies 844. Likewise, in all the months they have below the limit.
Except in some.
Yes, in some, and in March, that is March 2024, vacancy of 84 is shown. So at the time of filing of the writ petition also, in short, in other words, there was vacancy, existing vacancy, which is below the number of petitioners in the instant case. We have 72 petitioners, and here they have 84 vacancies. Of course, these things are not necessary, my lord. Even if there is excess appointment, we must be allowed to complete our probation. Suitability test may be conducted, and if we are found unsuitable, we may be
Okay.
allowed to
Recharged.
go. Yes. Now, an additional affidavit has also been filed before this honorable court on 7th of February this year.
Seven to 2025.
Yes, my lord. Where information has been received regarding the appointment of 187 O&M staffs under the respondent department. From 1st of January 2024 to 17th of December 2024. At Annexure 1, page 7 of the additional affidavit that I have filed this year.
Page.
Page 7. Page 7.
Okay. All right, okay.
Statement showing list of, it is clearly reflected in the heading at the top of the page. Statement showing list of O&M staff appointed with effect from 1/1/2024 to 17/12/2024.
Okay.
Now a list of 187 employees is given. Now all this indicates, it exhibits the capricious intention, the arbitrary actions of the state respondents in order to remove us from service on a false ground, on a false reason. And as is clearly in the conditions of service given in my appointment order, it is clearly reflected that I will be allowed to serve on probation for 2 years, and after that, suitability test will be conducted. And if I am found unsuitable, I will be discharged, as my lord has rightly pointed out. Now, I would only like to place a single citation in order to save this honorable court's time.
Yes.
State may have lakhs and lakhs of candidates seeking employment under it,
Yes.
but the candidate does not have lakhs and lakhs of jobs waiting for him or her. AIR 1991 101 paragraph 223.
AIA 1991 SC
Yes, my lord. This is a constitution bench decision.
still holds the field. Still holds the field.
Yes, yes, very much. 5 judges bench decision of the Honorable Supreme Court. This is a celebrated judgment.
Which one? Name, party's name?
Delhi Transport Corporation
Okay.
versus TDC Master Congress.
Paragraph?
Law students are taught
Yes.
this particular case. Paragraph 223. Paragraph 223 is a lengthy paragraph, so I would like to.
DTC and DTC Mazdoor Congress
Yes, my lord. Paragraph
versus
223.
DTC Mazdoor Congress.
Yes, my lord.
Paragraph?
223. It is at page 173. The portion that I want to read.
Page 100.
73. 173. There are about 5 or 6 subparagraphs here. I want to rely on 2 subparagraphs. 2 subparagraphs.
Page 173, yes.
Yes, my lord.
Hmm.
The left portion of the page. The employment under the public undertakings is a public employment and a public property. It is not only the undertakings, but also the society, which has a stake in their proper and efficient working. Both discipline and devotion are necessary for efficiency. To ensure both, the service conditions of those who work for them must be encouraging, certain and secure, and not vague and whimsical. With capricious service conditions, both discipline and devotion are endangered and efficiency is impaired. The right to life includes right to livelihood. The right to livelihood therefore cannot hang on the fancies of individuals in authority. The employment is not a bounty from them, and nor can its survival be at their mercy. Income is the foundation of many fundamental rights, and when work is the sole source of income, the right to work becomes as much fundamental. Fundamental rights can ill afford to be consigned to the limbo of undefined premises and uncertain applications. That will be a mockery of them.
Okay.
Now, the last para that I want to rely on, para 243 at page 188.
Yes.
Page 188. I would like to read the last sub-paragraph.
Yes.
188, towards the last portion of the page. That apart, the haunting fear of dismissal from service at the vacary of the concerned officer would try up all springs of idealism of the employee, and in the process coercions the conscience and degrades his spirit. The nobler impulses of minds and the higher values of life would not coexist with fear. When fear haunts a man, happiness vanishes. Where fear is, justice cannot be. Where fear is, freedom cannot be. There is always a carving in the human heart for satisfaction of the needs of the spirit by arming by certain freedom for some basic values without which life is not worth living. It is only when the satisfaction of the physical needs and the demands of the spirit coexist, there will be true efflorescence of the human personality and the free exercise of individual faculties. Therefore, when the Constitution assures dignity of the individual and the right to livelihood and the exercise of the power by the executive should be cushioned with adequate safeguards for the rights of the employees against any arbitrary and capricious use of those powers. Contract of service must be consistent with the Constitution. So here, I'm not saying that the service conditions were unconstitutional or they were arbitrary.
Only
I am saying that
discharge order.
it was not followed.
Okay.
So my humble prayer before this honorable court is that the impugned office orders by which I was terminated, annexures 74 to 144, it may be quashed and set aside. And I have given a particular statement in my written petition that I have not been gainfully employed elsewhere after my termination. Therefore, payment of back wages to the petitioners may be considered by the respondent department. On
Okay.
that issue alone, I would like to place a single citation.
You said you have submitted on a single citation, then again you're submitting double citation.
This is only on back wages.
Okay, back wages.
Yes.
Okay.
TTC Master Congress does not speak about back wages. Two 2009 to GLD 551. This is the Kohima bench decision. Paragraph 8. Paragraph 8.
Paragraph 8.
Yes. The legal position is settled by the apex court in several decisions, including the aforesaid cases cited by the learned counsel for the petitioner. The Supreme Court decisions have been, the citations are given in paragraph 4 of the judgment. The legal position is that once termination order is found to be illegal, consequential order of grant of back wages must follow unless there are reasons justifying departure from normal order. For denial of back wages, the respondent authorities must show justified reasons like that the petitioner has been gainfully employed elsewhere during the period of absence. So that is my entire submission. Yes.
Have you given the prayer for back wages?
Yes, yes. In my petition, I have.
I'll need the printouts.
Hello.
Yes.
May I please, my lord?
Mm.
Lordship, the petitioners are appointed by the office order, which my learned friend has just
Yes,
read.
yes. You see, but you see, they were supposed to be given 2 years time.
Yes.
So before 2 years, they were discharged.
Lordship, the issue is not that. The issue is not that, Your Lordship. Allow me to satisfy.
Then again, okay, but you see,
Yes.
they were discharged before 2 years, and then you were supposed to hold a test also.
Yes.
Eligibility test.
Yes.
That was also not held.
Yes. So, Your Lordship. I will explain those things, Your Lordship.
Okay.
I'll try to satisfy my Lordship. Allow me to take my Lordship to the office order, that is the appointment order, which my learned friend has read it out. However, Your Lordship, allow me to please take my Lordship to some of the paras in the order. Your Lordship will find it at page 45.
Page 45.
Page 45. Since my learned friend has referred to this order, I will also base my submission on this order.
Okay, all right.
Yes. This is an office order, Lordship, at page 45 of the read. Lordship, this is an office order appointing the petitioner. Now, Your Lordship, the petitioners are actually appointed on certain terms and conditions. Terms and conditions, Your Lordship. The first para, if I may be allowed to read the first para.
Yes.
Consequent upon the approval of government by letter number such and such, dated 19th of October 2022. So the appointment is on the approval of the government.
Okay,
Letter
okay.
dated 19th of October 2022. There is the first thing, my lord.
Okay.
Second thing, Your Lordship. And P and AR OM number such and such dated 3/10/2022. 3/10 P and AR OM dated 3/10/2022, my lord.
Okay.
Srimati such and such is the name of the petitioner, is hereby appointed as operation and maintenance staff, O&M staff, we call it, Your Lordship, in short. In the scale of pay, with grade pay, plus all other allowances as admissibles under the rules in force, Your Lordship, from time to time with effect from such and such and posted, Your Lordship, under the following service conditions. Under the following service conditions, Your Lordship. Number one, the appointee shall be on probation of 2 years. On completion of the probation period, all the appointees shall be subject to suitability test. This suitability test shall be conducted at the divisional level, and the division shall maintain their seniority based on merit. Two, only those or enough staff who qualify the suitability test shall be eligible to be considered for regularization against vacant sanctioned posts based on merit, list division-wise. Number three, other conditions shall be governed by the relevant rules or those issued from time to time. The last para, Your Lordship, the last para, it says, the appointment is on temporary basis and is liable to be terminated within the probation period with
Yes, yes.
1 month notice. So the condition is that, Your Lordship, of course, there are other conditions, but one very important condition that has been there in the work order is that it can be terminated. It can be terminated with 1 month notice during the probation period.
Yes, correct.
And the appointment is done, my lord, on the basis of the government approval and notification issued by the Personal and Administrative Reform Government of Nagaland. Your Lordship, these are some of the aspects that has been taken into consideration when the appointment order was issued. Your Lordship. So, during the probation period, if a termination is cast, what has to be done is that a 1 month notice has to be issued.
Yes.
Whether that was done or not, that has to be first seen, Your Lordship. Allow me to take my lord to the termination order.
It is there.
It is there. It is there. So no illegality as far as the notice upon the respondents is concerned. No illegality has been cast. Now, Your Lordship, why I'm stressing on the government approvals as well as the government notifications, 310/2022. Your Lordship, the government PNR notification 310/2022, Your Lordship will find it on my affidavit in opposition at page 8, my lord. Affidavit in opposition on behalf of respondent 1, 2, 3, and 4, my lord. If my lord has got it, I will
Yes,
be allowed
yes.
to read this, Your Lordship. Your Lordship, I have given a type copy, which is, shall I read from the type copy, my
Of
lord?
course, of course.
Office memorandum, this is issued by the Government of Nagaland, Personal and Administrative Reforms Department, Administrative Reform Branch, Nagaland, Kohima, dated 3rd of October 2023. Office memorandum. Your Lordship, subject, exemption of Power Department and Public Health Engineering Department from the purview of the PNR OM number such and such dated 12/7/2021. Your Lordship, 12/7/2021 OM, which is being referred here in the subject, is a notification banning the work charge employees in all the work charge establishment under the Government of Nagaland, my lord.
Okay.
And the body, Your Lordship. In pursuance of the cabinet decisions, vide such and such dated 29/2022, the following department: 1, Power Department, and 2, Public Health Engineering Department. We are concerned with 2, my lord, are exempted from the purview of the PNR OM number such and such dated 12/7/2021 and are allowed to maintain the work charge and casual employees as per the ceiling fixed by the Work Charge and Casual Commission. So the O&M staff, Your Lordship. The next it says, further, the nomenclature work charge is hereby changed to operation and maintenance staff in respect of the work charge employees under P and under Power Department and Public Health Engineering Department. So the O&M staff under these 2 departments, that is the Power Department and the PHD Department, they are allowed to be appointed as on the ceiling limit.
But the ceiling limit was in a ceiling, there was no ceiling limit.
There is a ceiling limit, Your Lordship.
87 vacancies were there.
No, Your Lordship, no, no, it is not there. I will satisfy my Lord. I will satisfy my Lord, Your Lordship. So the ceiling limit, as per the ceiling limit, they can employ the O&M staff under these two departments, Your Lordship. What is the ceiling limit? And what numbers has been prescribed as a ceiling limit, particularly for the responding department in this present writ petition, Your Lordship? Your Lordship, allow me to take my Lord to page 10.
Particularly in this head department.
Yes, Public Health Engineering Department, correct, ma'am.
Okay, page 10.
Page 10. Now, this is the basis of how the ceiling limit and the number of the ceiling limit came into existence as far as the responding department is concerned, madam. Page 10.
Yes.
Subject is proposal, Your Lordship,
Mm.
and recommendations of the Work Charge Department as per the meeting held on 11/2/2020. Your Lordship, I have also given a type copy. Your Lordship will find that it starts from page 13.
Type copy page 13, yes.
Yes, my lord.
Okay.
Yes, Your Lordship. I may be allowed to read the relevant para, my lord.
Yes.
Para 1.
Please read.
Principal Secretary, PHED, welcomes and acknowledges all the AHODs and HODs of the department having work charge employees in their establishment for attending the meeting. In the meeting, opinions, problems, and suggestions were sought for from the attendees. It was unanimously agreed that the work charge employees are behind the scene workers and are indispensable, who shoulders the main burden of all work, both in rural and urban sectors. However, the implementations of PNR-OM schemes for regularizations and absorptions of work charge and casual employees and revision of pay, that is 17 March 2015, restricted the department to make appointment against the vacancy caused by the regularized retired employees after 30 years of service. This has resulted in the reductions of work charge employees in many departments over the years. The work charge department are apprehensive that if this trend continues in the long run, there will be a huge shortage of work charge employees, which will paralyze the department in this context. The current scenario in some work charge department are highlighted below. Your Lordship, para 1, we are concerned with this. The PHED department, with the introductions of Jal Jeevan Mission, JJM, by the Government of India, which is to provide functional household water tap connections by 2024, sanitation programs, maintenance of water supply works across the state requires a minimum of 2,000 work charge employees. However, the work charge employees has been reduced to mere 3,736, and therefore the department is already facing a huge shortage of work charge employees. This was the opinion expressed. Your Lordship, may kindly come to page 14.
Yes.
Page 14, para 6. Para 6, my lord. It says,
Yes. Yes.
to sustain the vital maintenance services in the field by various departments, the following minimum ceiling strength is proposed by way of replacement in cases of retirement, death, resignations, and such replacement appointment to be done on fixed pay basis. The minimum ceiling strength at various departments is proposed to the higher authority for consideration as per the tabulations given below. Your Lordship, we are concerned with serial number 7 as in the tabulation.
Yes.
Department, serial number, department, Public Health Engineering Department, existing work charge employees, 736, and proposed minimum ceiling is 2,000.
Yes. Proposed, yes.
2,000.
Yes.
So the ceiling limit given to the PHE department for the O&M staff is 2,000. 2,000. Now, Your Lordship have seen the termination order, which wherein the reason for their termination is shown, is stated to be due to
Hmm.
exceeding the
Yes.
ceiling limit.
Hmm.
Exceeding the ceiling.
Exceeding the ceiling limit.
Yes, Your Lordship. Now, Your
But
Lordship.
according to the RTI, it did not exceed.
No, it exceeded, my lord. It exceeded.
Where in the RTI?
Yes, Your Lordship. Kindly come to, Your Lordship, kindly come to
Hmm.
page 220.
Of that WPC or
Yeah,
additional,
yes, of the WPC, my lord.
or additional affidavit?
No, of the WPC.
Okay.
Lordship.
220 of WPC, okay?
Yes. 220, my lord.
Yes.
Yes, Your Lordship. The first column, serial number, second year, month, third ceiling limit, fourth existing work charge and OM staff, and fifth vacancy. Your Lordship. I'll straight away take my lord to serial number 12, September 2023.
Okay.
September 2023. Ceiling limit 2000, existing work charge was 1981, and the vacancy was 19. The next, Your Lordship, October 2023. Ceiling limit 2000, existing 2068, vacancy minus 68, Your Lordship.
Okay.
It has crossed already. And why? How it was crossed, Your Lordship? Kindly come and see the appointment order. This was done in September 2023. That is, after the petitioners were appointed, the ceiling limit exceed.
Yes, yes.
Exceed.
Okay.
There is no vacancy, Your Lordship. In fact, the ceiling limit exceed.
Okay. True.
Now, Your Lordship, the petitioners are appointed as per the OL,
Hmm.
wherein it says that the department has to maintain the ceiling limit. And the ceiling limit given to the department was 2000.
Okay.
And the moment that is crossed, Your Lordship, it exceeds the ceiling limit.
All right.
Yes, and therefore, in the termination order, it is clearly stated that due to excess exceeding the ceiling limit, Your Lordship, the petitioner was removed.
On what basis? There was no eligibility test.
No, Your Lordship, there is no eligibility test.
74 petitioners were appointed.
Yes,
So who were discharged?
they were removed.
All the 74.
All of them. And you see, Your Lordship, they were appointed by same date appointment order. How do we pick and choose to keep within the ceiling limit? How do we pick and choose from among the petitioners whom to keep and whom to leave? Because that way we will be committing an illegality. They will be pick and choose then, Your Lordship. And therefore, all they came at once and they will leave at once, Your Lordship. Otherwise, picking and choosing from among them, Your Lordship, will be committing an illegality. That is the reason. However, Your Lordship, here, I wanted to take my lordship again to the last serial, March 2024. That is serial number 18. You see, Your Lordship, March 2024.
After they were released,
Yes.
then we got the.
Yes, it came within the ceiling limit again.
Okay.
So the question of whether the probation, Your Lordship, probation period was complete or not, that is not the issue here. The issue is whether the petitioner were terminated illegally or not. That is the issue here. Now, Your Lordship, my submission as far as the termination, challenging the termination order is concerned by the petitioner. My submission will be this, Your Lordship. Do the petitioner really have a right even to challenge the termination order?
During probation, they do not have. According to you.
Lordship.
According to you, during probation period, they do not have.
Yes, or for that matter, Your Lordship, do they have any right to even challenge, the termination order? Why I say this, Your Lordship? Why I say this, Your Lordship? Allow me. It says, appointment is on the basis of the approval of the government. Approval of the government, right, dated 19th of October 2022. Your Lordship, approval of the government is on page 44 of the writ.
Okay.
Page 44. I may be allowed to read this now. To the Chief Engineer, Sanitation, Public Health Engineering Department, Nagaland. Subject, administrative approval for filling up vacancies of O&M staff. Lordship, I think.
This time you can read it.
Yes, sir.
Rested this.
Yes, sir.
You can read it completely.
Yes, sir. I'm directed to refer to a letter number dated 17/10/2022 and to convey herewith the administrative approval to the proposal for filling up of vacancies of O&M staff in the department in compliance, Your Lordship, in compliance to the PNR OM number such and such dated 3/10/2022. I've referred that.
Yes, yes.
In phased manners under the following service condition. So there's a conditions prescribed here in Your Lordship. 1. Their pay and allowances shall be as per the revision given at clause 2.1 of the OM number dated 17/3/2015. Number 2, the appointment shall be on the probation for a period of 2 years. Number 3, on completion of the probation period, all appointments shall be subject to suitability test. The suitability test shall be conducted at the divisional level, and the division shall maintain their seniority based on merit. Number 4, only those OM staff who qualify the suitability test shall be eligible to be considered for regularization against vacant sanction posts based on merit list division-wise. Further, in order to maintain fresh fairness and transparency in recruitment process, you are directed to constitute departmental screening committee for the purpose. This is for your kind information and necessary action. Lordship, allow me to explain this after the.
Okay. All right.
Yes.
We'll continue after the break.
Yes.
Lydia.
was two very long,
Okay, okay. So if the time,
long arguments I have heard already.
if time doesn't permit, then we will be allowed to take the.
Sure, sure.
another
Yes, same day,
day.
like last time,
After 2 weeks, my
Okay.
suggestion, I for the respondent only,
as agreed by learned counsel for both the sides, list
Yes.
the matter after 2 weeks.
2 weeks.
All right, 28. Item number 28.
Yeah, 28, yeah,
Okay.
28. 2 weeks.
Yes. Government advocate. Yes. It's taking down the notes on that. Just taking down the notes on the diary. Huh? Oh, yes. Yeah. Otherwise, you'll have to argue again. You'll have to start again.
So Your Lordship, I was in page 44 of the read.
Yes,
That
yes.
is the administrative approval.
Yes,
Yes.
yeah,
Just to refresh our memory, Your Lordship, I'll just read the first and the last paragraph.
sure.
Page-
No, okay, I remember.
Yes. So Your Lordship, then Your Lordship, the last paragraph, it says further, further.
Yes.
In order to maintain fairness
Mm.
and transparency in recruitment process,
Mm.
you are directed to constitute departmental screening committee for the purpose.
Mm.
That means the department, the department is supposed to constitute a departmental screening committee for making the necessary appointment.
Yes, yes.
That kind of appointment was not done by the then engineer-in-chief also, Your Lordship.
Mm.
Yes. So what does the law say on this, Your Lordship?
Mm.
And a person is not appointed as per the constitutional provisions. Mm. What does the law say there, Your Lordship? Allow me to refer Lordship, to
So this departmental screening committee was not
no,
constituted then?
no, by the then chief engineer, Your Lordship.
Appointment was by the then chief engineer?
By the then chief engineer.
But not by this present?
No, no.
Mm.
Allow me to refer to Your Lordship to the decision given by the Honorable Apex Court, Your Lordship. Your Lordship is aware of this case. However, allow me to just refer a para to substantiate my submission,
Yes,
Your Lordship.
which case?
2006 for SSC. Page 43. Page 36, para 43.
I'll need all these printouts.
This is the famous Uma Devi case.
Yes, yes.
Lordship, para 43.
This is Uma Devi 1, no?
Yes, Uma Devi 1. Para 43.
Mm. Yes,
I may be allowed to read, Your Lordship.
please, please.
Thus, it is clear that adherence to the rules of equality in public employment is a basic feature of our Constitution. And since the rule of law is the core of our Constitution, a court will certainly be disabled from passing an order upholding a violations of Article 14 or in ordering the overlooking of the need to comply with the requirement of Article 14, read with Article 16 of the Constitution. Therefore, consistent with the scheme of public employment, this court, by laying down the law, has necessarily to hold that unless the appointment is in terms of the relevant rules and after a proper competition among qualified persons, the same would not confer any right on the appointee. Lordship,
Yes.
if it is a contractual appointment, here it is a case of this, Your Lordship.
Yes, yes.
The appointment comes to an end at the end of the contract. If it were an engagement or appointment on daily wages or casual basis, the same would have come to an end when it is discontinued. Similarly, a temporary employee could not claim to be made permanent on the expiry of his term of employment. It has to also to be clarified that merely because a temporary employee or a casual wage worker is continued for a time beyond the terms of his appointment, he would not be entitled to be observed in regular services or made permanent merely on the strength of such continuance. If the original appointment was not made by following a due process of selection as envisaged by the relevant rules, it is not open to the court to prevent regular recruitment at the instance of the temporary employees whose period of employment has come to an end, or of ad hoc employees who by the very nature of their appointment do not acquire any right, Your Lordship. Yes, by the very nature of their appointment do not acquire any right.
Yes. This is there in Umadabi's case.
Yes. Now, Your Lordship, the citation that there was the learned counsel for the petitioner is relying where at para 243, that the citation that they have applied, AIR, SC 243, also says, contract of service must be in consistence with the Constitution. So what does the Constitution say, Your Lordship?
Yes.
Yes, as far as the public employment is concerned, it's very clear. So the person whose appointment has not been done in accordance with the provisions laid down under the constitutions, such persons have any right to challenge the termination order itself, Your Lordship.
If I may, my lord, the learned government counsel is traveling beyond the pleadings.
Okay.
Let him show the paragraphs in which he has taken these grounds that he is presently submitting.
No,
Under
Your
the
Lordship. Yes, Your Lordship. Your Lordship, see, Your Lordship, the appointment order itself says that it has to be as per the administrative approval of the government. The administrative approval of the government says that it has to be as per the recruitment conducted through the departmental screening committee.
He's not asking for regularization.
No, Your Lordship. When the appointment itself.
He is only aggrieved by the termination order.
Yes. So when
he's ready to approach, he is ready to participate in any selection procedure.
Yes, yes.
So this is regularization.
No.
One of his cases for regularization.
No. When the appointment itself is illegal, that is why, Your Lordship, that is why it says, Your Lordship, if I may be allowed to refer to only that part, where it says, Your Lordship, therefore, consistent with the scheme of public employment, this court, while laying down the law, has necessarily to hold that unless the appointment is in terms of the relevant rules and after a proper competition among qualified person, the same would not confer any right on the appointee.
Yes.
Any right, Your Lordship. Any right to the extent of the termination order itself. Your Lordship. Now, Your Lordship, as far as the additional affidavit is concerned, Your Lordship, my learned friend has gone there and he has referred to the statement showing that there are as many as 187 employees has been appointed after the termination. These appointments are not under challenge. Are not under challenge at all in this writ petition. And therefore, this is not an issue. This is not an issue in this writ petition. The entire, Your Lordship, the entire foundation of the petitioner, if you see, Your Lordship, in the affidavit in reply. Affidavit in reply. Your Lordship.
They have not challenged what?
Your Lordship.
They have not challenged what?
No, they have not challenged this. The additional, the 187 employees who have been appointed after the terminations of the order, and by way of additional affidavit, they have filed this. But these 187 employees, the petitioners are not aggrieved by it because they're not challenging the appointment order whatsoever. And therefore, it has got no relevancy as far as this particular rate is concerned, Your Lordship. Now, Your Lordship, the
They were appointed after their termination.
yes, which is not under challenge and therefore has no relevancy as far as the present writ petition is concerned.
Okay.
Now, Your Lordship, the entire reply that they have given in the affidavit in reply, Your Lordship.
Yes.
Yes, affidavit in reply, Your Lordship.
Affidavit in reply, yes.
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 Yes, Your Lordship.
Hmm.
Is merely they are just saying that no, there is no excess appointment or the ceiling limit has been crossed. The entire reply is that, Your Lordship. Allow me to read some of the paras. Some of the paras, Your Lordship. Para 4.
There are 4 years.
There is statement.
Yes.
The statement made in para 4 of the writ petition is not admitted. For the same is misleading, unreasonable, and untenable. There is no excess appointment beyond the ceiling. However, just in order to illegally terminate the service of the petitioner, the state respondent has falsely claimed that there were excess appointments. This speaks about excess appointment. Para 5 again, Your Lordship. The statement made in para 5 of respondent 1 to 4 is not admitted for the reason that illegal termination was made on the fictitious ground that there were excess appointment, when in fact there was no excess appointment with the department. Para 7. The statement made in para 7 is not admitted for the reason that there is no excess appointment within the department of PHED, so far as the OM staff are concerned. In fact, even after the termination of the petitioner, the department has appointed 182 OM staff between March to September, along which shows that the state respondent has taken a false excuse just in order to terminate the petitioner and accommodate some others without allowing the petitioners to face the suitability test as provided in their appointment order. So again, relating to excess appointment, Your Lordship. Para 8, Your Lordship. The statement made in para 8 is denied, and the petitioner reiterated the statement made in para 8, 9, and 10 of this writ petition. It is further reiterated that there is no excess appointment within the department of PHED, and so far as the OM staff are concerned.
Yes.
So all excess, Your Lordship. Nothing more. They have not replied anything else, just that excess. Whether there was excess appointment or not, Your Lordship. And because of their appointment, what has to be seen in this case is that because of the appointment made, Your Lordship, whether the ceiling limit was crossed or not, that is the only issue. That is the only issue which has to be decided then in that case. Then, Your Lordship, the RTR reply that they have annexed. This is the document they have annexed in the writ petition. This is not my document they have annexed in the Lordship. Clearly shows that after their appointment, the ceiling limit of 2,000 was crossed by 2,068. That is excess of 68.
Yes.
With their termination, it came back within the ceiling limit. It came back within
What within the ceiling? Much lower than the ceiling limit.
Yes.
Why?
No, Your Lordship.
Why
Then
it has to come so low?
No, Your Lordship, because all of us, all 72 of them were appointed.
Yeah, I understand. No pick and choose policy.
No pick and choose. We have to terminate all of them. We cannot say that Mr. A can be kept, Mr. B can be kept. No. They came together by a different order, but on the same date. On the same date. And therefore, whom shall we keep it to be within the ceiling limit? Whom shall we keep it or whom shall be removed?
Okay, okay.
To-
I understand.
Yes, to keep that within the ceiling limit, Your Lordship.
Okay.
And therefore,
So this suitability test is still open, but
Still-
a committee has to be formed.
the committee has to be constituted for that. And Your Lordship, if the appointment is not done as per the constitutional provisions, then Your Lordship, termination cast or termination done, the petitioner or the person who has been terminated has got no right. It's very clear in there in this decided case, Your Lordship. That will be my suggestion, Madam.
So the suitability test is still open, you see?
Now, I may be given a short time to reply to the submissions made by the learned counsel. Firstly, this case revolves around only one issue, that is whether there is excess appointment or not. And the reason on which we were terminated is only on that ground alone. Now, whether there was TPC, whether screening committee was set up on that selection process after the probation is completed, how to be taken. These are not the grounds of termination, and these are not raised in the writ petition as well as in the reply filed by my learned friend. Now, the Honorable Supreme Court. It's a very short paragraph. Mohinder Singh Gill's case, a famous case, 1978. In paragraph 8, the state cannot improve their case by filing affidavit or by making oral submissions before this honorable court. The second equally relevant matter is that when a statutory functionary makes an order based on certain grounds, its validity must be judged by the reasons so mentioned and cannot be supplemented by fresh reasons in the shape of affidavit or otherwise. Otherwise, an order paid in the beginning may, by the time it comes to the court on account of challenge, get validated by additional grounds later brought out. We may here draw attention to the observations of so and so, so and so. Now, we have been terminated on the ground that there is excess appointment.
Yes.
They cannot bring other reasons before this honorable court by filing affidavit or by making oral submissions. Now, the RDI, I may be allowed to, since page 220, my learned friend has also elaborated enough on this, but I want to again reiterate a single point. Page 220,
yes,
serial number 18. March 2024, there is vacancy of 84 posts of O&M staff. So at the time of filing of this writ petition, there was 84 vacant posts, and
yes.
we are only 72 of us, petitioner and 71 others. So even if all of us are accommodated, 12 more posts will still be lying vacant. One. Secondly, why I have not challenged the persons who were appointed after my termination
Yes, yes.
in the additional affidavit, if I may. This is just in order to show, satisfy this honorable court that no, there is no excess appointment, there is vacancy, and the department have taken a fictitious ground in order to mislead this honorable court, just in order to satisfy this court on that point alone. And the fact that the petitioners those posts, they are still not disturbed, is very much clear from the affidavit filed by the state respondents, which I have received on 27th
You
of
see
May.
that column you are referring to, it is after your termination that
Yes.
vacancy arose.
Yes.
That is what he is saying.
Yes. And which is why, since they were not appointed in place of our vacancy, there is no need to challenge those appointments.
It was March 2023, no?
Yes. Here in the government affidavit also, they have mentioned specifically I may be allowed to refer to the last affidavit filed by the state respondents on May 27th, May 2025. I have received on 27th May 2025. Paragraph 4.
So according to you, there was vacant post, so you have not challenged their appointment.
Yes, here I may be allowed to read this. The very statement made by
What are you reading?
the affidavit filed by the state respondent.
Okay.
They themselves have stated that
Hmm.
the vacancy is still lying vacant. The last affidavit that they have filed on 27th of May, this is reply to my additional affidavit. After I filed the additional affidavit in February this year, in the month of May, they have filed this additional affidavit. Reply to my additional affidavit.
26 May.
Yes, my lord.
Okay.
I have received on 27th.
Okay, okay.
I may be allowed to read paragraph 4 at page 3. Since it's a
Yes.
lengthy paragraph, I may be allowed to read from the middle portion
Okay.
of the para.
Paragraph.
Paragraph 4 at page 3. Paragraph 4 starts from page 2 and continues the entire page.
All right, all right.
So since it's a lengthy paragraph, in order to save this honorable court's time, I may be allowed to read from the middle page only. As directed by this honorable court in its order dated 17/5/2024, directing the state respondents not to make any fresh appointments against the vacancy created by the termination of the petitioners during the pendency of the instant writ petition. The respondent outright is, as directed by this honorable court, has not made any appointment against the vacancy created by the termination of the petitioners, and the said posts are still vacant, which can be seen from the letter dated 28/4/2025, written by the chief engineer and head of department PHT Nagaland Kohima to the senior government advocate.
So this was stated by the order in this court, in this case.
Yes, at the stage of motion.
At
So
the
there is
stage
a
of
stay
motion.
order, yes. So they have not violated it, and the posts are still lying vacant. So at the cost of repetition, there was no need for me to challenge the appointments which were made.
No, but this is after.
Yes.
Not,
Yes.
so
Yes.
this is not relevant actually.
Yes.
This affidavit was filed.
Yes, my lord. Now, in the writ petition itself, there are 84 vacant posts of O&M staff. We are only 72. Even if all of us are accommodated, still 12 more posts is lying vacant, and it does not, proportion does not mean that I'll be appointed automatically.
Okay, I understood, yes.
Yes. But only
Posts
five of us,
are already
only one of us may be selected by the department.
So you received that copy of that, you received this, okay. After the RTI, you came to know that
Yes,
after your termination that
Yes.
these posts are lying vacant.
Yes,
Okay,
yes.
okay. I got your point. Yes.
I'm deeply obliged. So the condition that there was excess appointment is a fictitious ground being taken by the.
No, earlier it was okay, but
Yes.
later it's vacant now.
Yes.
It is vacant.
Yes. And
So
it's four posts
that
still lying
it's,
vacant.
according to him, it's still open
Yes.
for consideration.
Yes, my lord.
You will have to appear for an eligibility test.
Yes, my lord.
Okay, there has to be a direction by this court.
My lord. As for the peg wages, my lord, I leave it to the wisdom of this honorable court and to the wisdom of the department.
What?
Regarding peg wages, whether to be paid or not, let the department
Back wages,
consider. Yes, let the department consider it.
Your lordship,
Whether I am entitled to it or not.
your lordship, as I have got only one reservation here, only one reservation, your lordship. As far as the prayer of the petitioner is concerned, your lordship will find that at page 41. The prayer is specifically to quash and set aside the termination order
And to pass any.
and to reinstate. So they reinstate, but I have got reservation there, your lordship.
Against the reinstate.
Yes, only that part. The rest, no, your lordship. I have got no other this thing, but the reinstate part, your lordship. Now, why I have got reservation, your lordship? Because I did not finish the para that I have read. Your Lordship, from the citation that I have placed.
Mm.
Just a line, just a line.
Which one, which one?
Yeah,
That
that,
Umar Davis case.
yes, just one line.
I know, you didn't finish.
Yeah, I did
And-
finish that, just one line.
I
He is
interfere.
traveling beyond the pleadings.
Huh?
He is traveling beyond the pleadings.
No, Your Lordship. What does the court says? Just that, the reinstate part only, nothing more, Your Lordship, nothing more. Your Lordship, the 12th line from the bottom,
Yes,
12th line from the bottom that starts with the High Court.
yes, you marked it.
Yes, 12th line from the bottom of the paragraph, Your Lordship. The High Court acting, it says, Your Lordship, the High Court acting under 226 of the Constitution should not ordinarily issue direction for absorption, regularization, or permanent continuance unless the recruitment itself was made regularly and in terms of the constitutional scheme. Merely, see, Your Lordship, this is important. Merely because an employee has continued under the cover of an order of the court.
That is not the prayer in the instant case.
Lordship, because they have interim cover here, Your Lordship. Merely because an employee has continued under a cover of an order of the court, which we may describe it as litigious employment. In the earlier part of the judgment, he would not be entitled to any right to be observed or made permanent in the service. In fact, in such cases, the High Court may not be justified in issuing interim direction, since, after all, if ultimately the employee approaching it is found entitled to relief, it may be possible for it to mold the relief in such a manner that ultimately no prejudice would cause to him. Whereas in interim direction to continue his employment would hold up the regular procedure for selection or impose on the state the burden of paying an employee who is really not required. The court must be careful in ensuring that they do not interfere unduly with the economic arrangement of its affair by the state or its instrumentalities, or lend themselves the instrument to felicitate the bypassing of the Constitution and statutory mandates. So here, Your Lordship, it's clear. So as far as the reinstatement part is concerned, Your Lordship, I have reservation on this, Your Lordship.
Okay.
I'm deeply obliged.
I won't be able to pass judgment today itself. I'll have to ponder over it. It's a serious matter.
My lord, I may be allowed to continue my profession. Let me face the suitability test. That's all. I'm not praying for regularization, nothing. If the
I understand,
if I
yes,
suitable, let me be dismissed.
The citation is clear. As far as continuation observance, the citation is very clear.
This is, the Uma Devi case is not on probation
No,
employees. Yes,
no.
yes. He is trying
No,
to,
temporary,
he is,
they are
he is trying
temporary in
to,
nature.
he is trying to fit a square into a triangle.
That is presumption.
Totally irrelevant.
Yes. He's a temporary, they are temporary employees of Lordship. It's very clearly mentioned in the appointment.
And second thing, he is traveling beyond the pleadings.
So you want
Otherwise,
to
if you-
continue in service?
Yes, yes.
There will be reinstatement, Your Lordship.
Otherwise, if we speak about Uma Devi, ML Kesari, Projonat Kankuli, the hearing will not will not conclude in 2 days also. I have stuck
Take part in
to
suitability
that
test.
sole crown only, yes. And that crown is only
So
the
this
relevant crown
suitability test,
in this instant case.
suitability test will be allowed without doubt, because he also has no
My lord,
objection,
my lord,
but a committee has to be formed.
my lord,
But this other one, I'll have to ponder over.
my lord,
it.
my lord, my lord. I leave it to the wisdom, the
Okay.
other part. of this
Even that earlier argument of that today, earlier part of the argument, you were not there, Jimomi was there. So they have also, one part they have considered, I think, so far as I remember. One part they have considered and one part they have objected. Actually, this happens with most of the service loss
Yeah.
cases.
Yes.
Heard Learned Counsel, Mr. Your name?
Cynthia, my lord,
Cynthia Angar for the
listeners.
petitioners, comma, and learned, and learned senior government advocate,
Yes.
Mr. N. Angami for the respondents, reserved for judgment and order. Any other case? Okay.
I am deeply obliged.
Will I be able to absorb, receive so much? Will I be receptive? I don't know. You can submit, I'll reserve it, but I won't be able to receive. Already it will be at the saturation point now.
Yes, correct, madam, correct.
Much obliged.
For hearing item number 27.
You want to continue?
It's a part hard matter.
Oh, that
Uh,
matter.
that-
Oh, that matter.
Like case slow and I may be allowed to read out.
Oh, okay. I remember. Part matter that day, no?
Yes, madam.
Yes.
Well, first, I'm relying on AIR 1966
AR 1960.
AIR 1966 SC 492. Para 6.
AIR 1960.
6.
SC
SC 492.
492. Para 6.
Para 6, madam.
Hmm.
I'm allowed to read out.
Yes.
This
Party's name, what are the party's name?
party name is Chai Shankar versus State of Rajasthan.
Okay.
It is admitted on behalf of the state government that teachers from service of an incumbent by way of punishments amounts to removal from service. It is however contended under the regulation all the government does is not to allow the person to be reinstated. Government does not order its removal because the incumbent himself give up the employment. We do not think that the constitutional protection can be taken away in the manner by a side win. While on the one hand, there is no compulsion on the part of the government to retain a person in service if he is unfit and deserves dismissal or removal. On the other, a person is entitled to continue in service if he wants until his service is terminated in accordance with law. One circumstance deserving removal may be overstaying one's leave. This is a fault which may entitle government in a suitable case to consider a man as unfit to continue in service. But even if a regulation is made, it is necessary that government should give the person an opportunity of showing cause why he should not be removed. During the hearing of the case, we questioned the government advocate general what will happen if a person owing to reason wholly beyond his control or for which he was in no way responsible or blamable was unable to return to duty for over a month, and if later on he wished to join as soon as the said reason disappeared. Will in such a case government remove him without any hearing, relying on the regulation? The learned government advocate said that question will not be of removal but of reinstatement, and the government might reinstate him. We cannot accept this as a sufficient answer. The regulation not ask for the reinstatement but literally found to this that a person will not be reinstated if he is ordered to be discharged or removed from service. The question of reinstatement can only be considered if we first consider whether the person should be removed from discharge from service. Whichever we want to look at the matter, the order of the government involves the termination of the service when it will be within discharge. The regulation involves a punishment for overstaying one gift that was disclosed on the incumbent to take away reinstatement by showing cause. It is true that the government may visit the punishment of teachers or removal from service on a person who has absented himself by overstaying his leave. But we don't think that government can order a person to be discharged from service without at least telling him that their purpose to remove him and giving him an opportunity of showing cause why it should not be removed. If this is done, the incumbent will be entitled to remove and no question of reinstatement will arise. It may conveniently described by seeking reinstatement, but it is not tantamount to say that because a person will only be reinstated by the authority, that the removal is automatic and outside the protection of Article 311. The removal is removal, and if it is punishment for saying one leave, an opportunity must be given to the person against whom such an order is proposed. No matter how the regulation described it, to give no opportunity is to go against Article 311, and this is what just happened here. Here also, in this case also, the petitioner was given no so cause. So at least the petitioner deserved an inquiry, a so cause, for him to appear and explain his case. So this was also done, and which is violation of Article 311, which is clearly validated by the department. Here, in this case, Chai Shankar was removed without giving a so cause, without inquiry from the department, without any opportunity to present his case why he was absent or overstayed. In the adjustment, Chai Shankar was without an opportunity to so cause against the proposed removal from service on his overstaying his leave, and as soon as an opportunity is given to him, his removal from service was illegal. He is entitled to this declaration. The order of High Court must be set aside. So in this case, he was removed from service without so cause. But our case, we are not removed from the service also. So, my lord, may kindly appreciate this text also. And the other judgment is 2012 3 SCC, para 17.
How many days he was away on leave? Jaishankar?
Para 7,
And this judgment holds the field.
2012.
1966, this judgment.
2012 3 SCC. Pustakan,
Are you sure this judgment holds the field? Jaishankar, how many days he was on leave?
big pardon.
Jaishankar,
Yes, my lord.
he was on leave for how many days? For 22 years.
No, my lord, but the principle of law is same, my lord. Maybe 1 day or 5 years, the principle of law is same. So, clause 11, clause 2 clearly says a person cannot be removed from service unless inquiry is done. My lord, next case law I'm relying on 2012 3 SEC, Krusnakan B. Parmer versus Union of India and another, para 17. If the absence
Yes, please read.
If the absence is a result of compelling circumstances under which it was not possible to report or perform duty, such absence cannot be held to be willful. Absence from duty without any application or prior permission may amount to unauthorized absence, but it does not always mean willful. There may be different eventualities due to which an employee may abstain from duty, including compelling circumstances beyond his control, like illness, accident, hospitalization, etc. But in such case, the employee cannot be held guilty of failure of devotion to duty or behavior unbecoming of a government servant. In a departmental proceeding, if allegation of unauthorized absence from duty is made, the disciplinary authority is required to prove that the absence is willful. In the absence of such finding, the absence will not amount to misconduct. In the present case, the inquiry officer. So, my lord, whether there is application for leave or not, it is Supreme Court have clearly defined that the department has to find whether the absence is willful or not. It was beyond its circumstances or not. So in this case, it's a life threat, my lord. It's a life threat case, and respondent have advised him not to come to office. So he did not come in obeying his advice of his superior. So in my representation also, it is clearly written. 2010 also he joined, but still then, till 2010 he was threatened, my lord. 2010 also he joined. I annexed in my petition also. So it was beyond his circumstances, and the employer is supposed to give him security, but the state failed to do so. So and the state has failed to protect him. Moreover, the miscreant have threatened the state not to draw his salary. Not to draw his salary also. So this is not only life threat, but even the state have warned the department.
Who will give security to a grade 4 employee? Who will give security?
My lord, it's not about grade 4 or grade 3, my lord. The thing is, he happened to be a victim, and the state is supposed to protect life and liberty of an individual, of a citizen. But the state, instead of protecting his life and citizen, was advised the petitioner not to come to office. So in such situation, and he's a layman, and this is back in the year 2000. Now people are aware of FIR or police complaint. At that time, he's a layman. He does not have the privilege and facility also, my lord. So the state have contended that it is 20 years, but 2010 also, after 7 years, he came to the office, but he was not able to mark his attendance. So, my lord,
Not to draw the salary. This is very absurd. Appears to be very absurd. If some person will threaten anybody, they will say that you don't come to office, but not to draw salary. Who will say not to draw salary?
His screen had warned the executive engineer not to release the salary of the petitioner. So normally a person will feel intimidated. And my lord, I also rely on one Yes, Sornamai Sharma versus State of Assam, Department of Forest and Environment, disposed on 5/10/2013. In this case, the petitioner, the writ petition was originally filed by the husband, but he died during the pendency of the writ petition. So the fact of the case is that he was appointed in the year 1950. 1950. But from 1956, but from 1973 to 1992, 1990 for he was
Similar,
absent,
absent, similar
15
time.
years absent because of his mental illness.
Give me that.
Mental illness. And after that, his absence was declared as non-dice. Leave without pay. So he was again
You
given.
see, mental ailment, they are, if the petitioner is suffering from mental ailment, not in this case.
No, he has mental.
Yes,
illness.
it has.
I pleaded in my petition.
There are, I think there are some exemptions. So he can, I think he will get the wages. You have to approach the department. You'll have to approach. I know about it. Mental ailment, even they get the retirement benefit also if he's not attending services. He'll get the salary, he'll get the retirement benefit, everything he'll get. If the petitioner is suffering from ailment like schizophrenia, it has to be serious mental ailment like schizophrenia or this type of clinical mental ailment, bipolar disorder, or split personality disorder, this type of clinical mental ailment. So you can approach before it's too late. You must approach the department also with the certificates. I think he has medicines also.
But my lord, the state have stated he is out of service, so may not entertain this.
No, even if he's out of service, you can take it. You can submit a representation. That much I know. And I have seen there are some cases where husband and wife were working, then wife got transferred to another, husband got transferred to another place, then wife stopped serving the government. And then after 10-15 years, then she got reinstated 10-15 years, even more, I think. They had 3 children, 10-15 years, she got reinstated, she got back wages, everything. Everything. I have seen such cases. But those cases are not similar to this case. I don't have the case law with me at present. But it has happened there, over there also. But the case is not with me now. It was a very old case, so I have forgotten.
In fact, Your Lordship, if at all the mental element is concerned, if the
No, this
petitioner-
woman was not ailing mentally.
Yeah.
Her husband got transferred, and one fine day, since then, she went with her husband and she was not attending without any reason. But she got everything, and then she got reinstated also after several litigations are going up to the High Court also, maybe, I don't know. She got, I don't know what she has placed. I've forgotten. It was during my early service days.
Yeah.
Then I came across this case, but now I have forgotten actually.
Lordship. As
I
far
don't
as,
have the case law with me now.
yes, Lordship is correct. As far as Your Lordship, the issue of the mental ailment is concerned, as far as this case is concerned, these are actually subject to views expressed by an expert who is a doctor, Lordship, without annexing any documents that
No,
has-
it has to have the
Yeah.
clinical mental ailment.
Yes.
Just that sometimes he's suffering from depression, sometimes he's suffering from mood swings. This will not work. This will not work. It has to be a clinical mental
Yes,
ailment.
it has to be done clinical expert, not in the way of a submission like this, Your Lordship. In fact, as I was telling you the other day, Your Lordship, I'm not blaming my friends over here, but if you look at or if you read the petitions para by para, and the representations that he submits, it contradicts each other,
Yes.
which is making it more suspicious, and at the same time, it's like it's completely misleading this honorable court, Your Lordship. Was subject to the satisfaction that my another friend gave it before this court, man.
My lord, I may be allowed that, in the prayer, we have prayed for reinstatement, my lord. But, if the lordship pleases, we can direct the department to hold an inquiry as per Article 311, which I relied on the judgment which I placed. At least departmental inquiry. And if he is reinstated or discharged officially, then at least we can approach the appropriate forum again as per the Nagaland Service Appeal and Conduct Rules also. But now there is no official termination also, and this is his right, which is constitutional right, as laid down in a number of cases. Now on the two cases, Jaisankar and
Okay,
yeah, at least that.
you give me the printouts. Because I am winding up tomorrow, so I don't know, I'll be able to
Yeah.
dictate and complete, and then
Yes.
because I have tomorrow I have another, I'll deliver the judgment tomorrow, another one case that they have concluded the argument.
Yes.
So I'll deliver the judgment tomorrow.
Lordship.
So I won't be able to I think complete this. It was very short,
Yes.
and that morning case was also very short.
Correct.
Had I stayed over, I could have dictated the judgment.
Yes.
Tomorrow I'll be traveling back.
Yes, correct.
So I'll have to take the records with me.
Correct. My lord, if the submission made by my learned friend just now, if that is taken into consideration, I would like to give a very fair submission, Your Lord.
Okay, yes. Okay, sure.
Yes.
You have to reply, of course.
Yes, I would like to give a very fair submission by saying that, my lord, by documents and by going through the writ petitions, I have shown before this honorable court that there is
entangled in their own web of lies.
and not only that, Your Lordship, it is the petitions has been drafted and the documents that they have placed clearly indicates that they did not approach this court with clean hand. That itself, Your Lordship, is liable to make this writ petition dismiss.
Yes, there are judgments also.
Yes, there are judgments. I sincerely, since my lord already knows it, I don't want to place those things and waste the court time. Having said that, Your Lordship, if disciplinary proceedings as far as that is concerned, I would like to give a fair submission here, Your Lordship. Let the writ petition be dismissed because, Your Lordship, there is a misleading statement, misleading for the fact that they have tried to mislead this honorable court to get an illegal order. So dismiss the writ petition. However, yes, if an inquiry in order to bring out a termination order, if an inquiry can be set up by the department by following the Nagaland Disciplinary and Appeals Rules 1967. There is a Discipline and Appeals Rules, Nagaland Services Discipline and Appeals Rules 1967. If through that, if any disciplinary proceedings can be initiated.
Do you have a copy? You give me a copy. Nagaland,
Nagaland State Disciplinary Appeals Rules 1967.
We also have disciplinary and appeal rule in Assam also.
Yes, correct.
You give me a printout of that also. This two and then that also.
Yes, by initiating a discipline, if at all that law permits in it, Your Lordship, then yes. But, Your Lordship, my humble submission and my humble prayer is, Your Lordship, dismiss the writ petition because this will set a bad precedence, my Lord.
Yes.
This will set a very bad precedence. I'm deeply obliged, my Lord.
Hard Learner Counsel, Mr.
I'm Pakin Ritsapo.
Huh?
Pakin Ritsapo.
Pakin Ritsapo for the petitioner and Learned Senior Government Advocate Mr. N. Angami.
Lord.
Reserved for judgment and order.
Deeply obliged.
You give me the and this you stick like that. I have I have marked as day 2. 2 sets of arguments. So this I have marked as day 2. You can give it like this.
Yes.
Otherwise I'll forget everything.
Alright,